Good morning, ladies and gentlemen. My name is Ayabaziwe Isaac, an associate partner at Nakachwa Matovu and Company Advocates. Ladies and gentlemen, fellow members of the bar, judicial officers, distinguished guests, we welcome you to this continuous legal education session, which is an opportunity to refresh, refine, and elevate our collective craft. Today's theme, ladies and gentlemen, is practical, technical, and human. We'll be walking through the realities of criminal litigation from the defense, the prosecution, and the judicial perspectives. Ladies and gentlemen, we are fortunate to have a panel comprising some of the sharpest and most experienced minds in criminal law practice in Uganda and beyond. Ladies and gentlemen, allow me to introduce a name that needs a little or no help from me. When we speak of criminal defense in Uganda, one name consistently appears above all else, and that is Mr. Macdusman W. Kabega, a man whose courtroom presence is so commanding that even the walls of the court seem to sit up straighter. Briefly, he's a man of very many qualifications, and strong ones for that matter. I believe he'll have a lot more to add when he comes. He holds a Bachelor of Laws degree from Makerere University. He holds a diploma in legal practice from the Law Development Center, Kampala. He holds a certificate in contract negotiation, Worthington International Institute in the UK. He holds a certificate in prosecution techniques with the FBI National Academy, Quantico in the USA. He holds a certificate in commercial crimes, University of Zambia. He holds a certificate in white collar prosecution in ILI in Rome. That is only part of his vast qualification. He will have to add more. His experience, he worked as a state attorney in the Ministry of Justice and Attorney General, rising to the rank of deputy DPP. Actually acting DPP in that is between 1993 and 1994. He was a visiting external lecturer and external examiner at the Law Development Center, where all of us have passed. He was appointed defense counsel, accredited to the International Criminal Court in The Hague, Netherlands, from 1994 to date. And he is also a member of the International Criminal Court Law Society of Accredited Counsel. Ladies and gentlemen, today we have a privilege to tap into the wisdom of someone who has argued some of the most defining criminal cases in our jurisprudence. Please join me in welcoming the incomparable Mr. Macdusman Kabega. You're welcome, sir.
Thank you, Isaac. And good morning, ladies and gentlemen, and fellow land friends. It's always a privilege to be here, to be part of this continuing legal education in conjunction with the Uganda Law Society. I've been asked to say a word on the topic that is criminal litigation best practice, a view from the defense perspective.
A slight interruption.
Yeah.
I have been notified that the vice president of the ULS is actually online.
Okay.
You can give the members a greeting, and then we can invite the vice president of ULS to make his remarks, and then we can begin. Thank you.
Okay. The vice president of ULS, greetings to you and all members. May I now invite you for your comments before I go forward. Mr. Vice President.
I'm truly honored, Senior Counsel Mark Desmond Kawega. I do appreciate and I'm so honored for your introduction. I believe we also have Senior Kamba Hassan as one of the speakers, Miss Immaculate Angutoko, His Worship Timothy Lumunye, Senior Counsel present online, other members of the bar. Good morning to you all. I do bring you greetings from the Radical New Bar Governing Council, and I convey this from the leadership of the society. Some of them are online now, and the president is also not able to join us online. It is really my pleasure to welcome all of you today for this criminal law CLE training. I want to believe that this training is very essential and important, not only for criminal law practitioners, but also other members of the bar, other people. As you notice, it's very hard to run away from criminal law practice. I've had colleagues before who say, I'm not a criminal law practitioner, but you're representing your client in a commercial matter, in a land matter, and before you know it, the client has been arrested, the client is being charged with other, offenses, including those under the Anti-Corruption Act. And you find you have no choice but to represent your client because your client requires a holistic representation. So I believe this is a very important training. And when I looked at the topics listed and the panel of our speakers, I have no doubt that the members attending today are very lucky to have this kind of experience, to have the brains we have here today, looking at topics like criminal litigation, best practices. I've seen topics like criminal appeals litigation, and the complexities inherent in criminal law practices. I have had an opportunity of interacting closely and working closely with almost, I think, with all our panelists, Senior Counsel Kawega, like the moderator just mentioned. Honestly, it does not need a lot of introduction. Hassan Kamba, it goes without saying, and my very good friend, Immaculate, I like calling her Madam President. We are lucky to have you, and thank you for allowing to join us and share your knowledge. His Worship Timothy is one of the best, I believe, that area, and is always willing to share his insights and experiences freely as compared to some members of the bench. So we are lucky to have the people today. I really do extend my heartfelt appreciation to all of you for allowing to spare your time, to sacrifice, and be with us today at the all the members present. I encourage all of you to participate actively and ask questions. Do not let this opportunity pass you by without benefiting from today. So I believe this is an opportunity for all of us to learn something new, share experiences. Let it be a session where we're all benefiting. I wish you all the best, and I believe it's going to be an exciting session for all of us. Thank you very much, and I give it back over to you, Isaac.
Thank you very much.
Thank you very much. Thank you very much. Thank you very much. Thank you very much. Thank you very much. Thank you very much. Thank you very much. Thank you very much. Thank you very much. Thank you very.
All right. Back here, I would love to bring to the attention of the persons that are present for this CLA training session. So this is going to be our agenda for the day. The Honorable Vice President is done with his remarks. We shall begin with a presentation from Mr. Makdusman Kabega on criminal litigation best practices, and he's going to give us a view. He's going to give us a view from the defense. Then we shall have a Q&A after him, and then I'll be back with the next speaker. Like I had earlier said, Mr. Kabega leads us into the very engine room of criminal defense. This is a chance to understand what distinguishes good advocacy and great advocacy. Please, Mr. Kabega, you can start from there.
Thank you, Isaac. Maybe from the onset, let me say that I was contacted at short notice, so I've not been able to. Was contacted at short notice. I didn't want to frustrate the this, so what I've done is simply to jot down the basic points in my view as a practitioner, what I perceive to be the best practice, and of course bearing in mind that the primary role of a defense counsel is to serve the interests of his client with devotion, courage, to ensure that his legal rights are protected. And that is that if you agree to take on a brief to defend an accused, what is expected of you is to accomplish his instruction. Now, there are two scenarios. One, getting instructions to represent a suspect after he has been apprehended. Now, at this stage, of course, there is a process of collecting evidence, which the CID begin with. So here, what would be your role as a defense counsel? I would imagine that the first thing would be to make sure that due process is followed to the letter in whatever the CID have set out to do. And at this stage, much as I would advise that you try to talk to the client as much as possible, many times the CID may not allow you, but whatever little time you may get to access the client, the basic thing, or the first one, will be to explain to him how he's going to make his statement and how he's going to approach the questioning or interrogations that he's going to face, and of course, advise him on the nature of the statements that you may be required to make. One, which is a plain statement. Sorry? Okay. A plain statement, or what is called a charge and caution statement. And so you should explain to him the difference between the two. And of course, ensuring that he does not implicate himself unless if informs you that he's willing to admit or to confess. Now, the second aspect is when you were approached after the suspect has already been charged and maybe investigations have been completed and the file or the case is now ready for hearing, whether before the magistrate's courts or in the High Court. So either way, you need to get to the client and then you see how we are going to proceed. Now, so what should defense counsel have to do or do when he's getting the instruction? I believe the first and most important thing is to create a trusting relationship. Now, here there are two scenarios. One, you may get a walk-in client to the office, to the chambers, who comes and is bringing instructions to you. Or you may get a client who is coming in with somebody you know or somebody who knows you, and maybe you have worked for somebody and is being recommended that you are the person who should represent him. So, when you get any of these two types of witness or clients, the first thing should be for you to foster a trusting relationship with the accused. You need to be honest with him that whatever he tells you will not be divulged to third parties. And many times the accused may fear to tell you the full story, thinking or having at the back of their mind that the lawyer may divulge some of the information given to him. So here, in this relationship, you need to ask the accused to narrate to you the story in detail. Pay extreme attention to the details he's giving, and please, you also ask for details from the client. And if need be, actually do cross-examine and re-examine him so that you get to know the full insight of the case that you are going to go in. So by doing this, all this, you will at the end of it all come to know whether the case against your client is a strong one or a weak one. Whichever way, then that will give you, or rather notify you, how you are going to move forward. The second aspect, the defense counsel, is that you need to also thoroughly investigate and find ways of challenging the prosecution case or evidence. If disclosures have been given, you will need to find out from the accused who these witnesses are, find out from him whether he knows them, what does he know about them, what is he telling you about the evidence which they have in their statements. So at this stage, you will need to go through the statements one by one with your client and try and cross-examine him, if I may use that word, the witness statement vis-a-vis what he's giving you. And then at the end of it all, you'll gauge whether the witness is actually telling the truth or whether your client has not told you the full story. So investigation is a very important aspect of a criminal defense lawyer. That whatever you get from this interaction, or rather investigation, will also lead you to the position of the kind of defense you may want to come up with, and whether what the accused is telling you is viable or not. Secondly, in this investigation, you will need to find out if there is any improper conduct by the police in the way they conducted the investigation. And if you see that there is any improper either collection of exhibits or an improper manner in which your client has been treated, you note it, and at an appropriate time during the trial, you see how you can challenge that evidence. Now, after the investigation, the next item which I have is the analysis of the evidence. Here, all that will be required of you is to carry out a thorough analysis of all the prosecution evidence provided in the witness statement. You have gone through them with the client. Now, it is up to you to look for inconsistencies between statements against statements. Look out for possible biases. Also consider the admissibility, and also consider the fact that you may perhaps be able to use some of what they are providing in your possible defense. Now, by this, you try to create a situation where witness A as against witness B will either not be believable, or because of there is a lie he has in his statement, or inaccuracy, or the fact that he's talking about an incident which actually is not conversant with. Then the next item which I have is the preservation of evidence. As a defense counsel, you have to ensure that evidence that requires to be preserved was dealt with in accordance with the law. Ensure that there is no tampering or evidence being lost, but also look out for the chain of movement of exhibits? Do the witnesses create a gap in the movement of exhibits? Do the witnesses create a scenario where the one who picked the exhibit is not indicated? Does the evidence indicate we don't know where the exhibits were stored? Things like that. Then obviously the next item would be that you as the defense counsel, you need to understand the charges that have been laid against your client. In this, what I mean is that you need to know the elements of the offense that your client has been charged with. Having looked at the elements of the offense, you consider that vis-a-vis the evidence that has been provided. Does the evidence provided prove each and every element? Identify which witnesses prove element A, identify which witness proves the second or third element of the offense, and then see how your cross-examination is going to be directed towards whichever witness has been brought to prove what element of the offense. And at the same time, also try and see how or which witness am I going to use to put my case, to bring it through to the court. Because you can always bring out your case through cross-examination by putting your case to a witness. And obviously, if the witness agrees with you, then you are home and dry. We have pre-trial proceedings. Pre-trial proceedings, this will come in obviously at the time of immediately after your client has been arrested, you engaged, has not yet been taken to court, and so you need to engage the police to see how you can secure bond if possible. And there, of course, you need to get the details of the possible sureties from your client. And then, of course, if the matter goes for trial, or rather, yes, then you consider bail and get also who will be the best sureties for your client, and obviously what does the court require from those sureties. Now, there are cases where after a thorough analysis of the evidence that has been provided or disclosed, after you have had an interview with your client and you feel that the case is too strong against your client, then you need to talk to your client and educate him about what is called the plea bargain. Take him through what plea bargain is all about. let him understand that if he plea bargains, he gets a lesser sentence, and in terms of imprisonment or a fine. And then, of course, if he agrees with you, then you can initiate the process of plea bargaining with the DPP's office, and there ensure that you come up with the best possible outcome for your client, and that is that reduction of the sentence as much as it is possible, and even a fine or a caution for that matter. So this aspect has to be explained to the client thoroughly so that he understands it, he knows the consequences, and before you agree with him, he's fully convinced that that is the best alternative for him to take in the circumstances, vis-a-vis going through a trial, and at the end of it is given a number of years in terms of sentencing. The next item which I have is digital evidence. Because these days, in many cases, capital in nature, even those which may not be capital, the police are now trying to use video recordings, reconstructing of scenes of crime, recording them, and also getting cameras where an offense was committed from neighboring cameras and use them in proceedings. So, as a defense lawyer, you obviously have to find ways of getting copies of those videos as part of the disclosures. And once they are provided, sit down with your client, go through them slowly. Ask him about each and every aspect of what is being shown on the screen. How did this come about? So that you vividly know and understand the case thoroughly. And of course, as you go through with him, you also interrogate him to know and understand why is this like this in the video, what happened here, and things like that. And of course, here, you need to be conversant with the law relating to digital evidence, like the Computer Misuse Act, the police standing orders, exhibit management guidelines, because these are all legislation which go hand in hand in that area. Now, you also need to find out if the client has witnesses you may want to use to defend him. Let him avail these witnesses, sit with them, interview them thoroughly, put to them the evidence which you have, and see their narrative. And after that, then you decide whether they can be used as a witness or not in support of your client's case. You may also need to discuss with him, for example, where expert witnesses are going to be used in the case. For example, handwriting expert, pathologist, if, for example, a doctor performed a post-mortem, there is a post-mortem report on the file, and when you look at it, you are doubtful about certain aspects of the findings. So, make a decision whether you will need a third, or rather a second opinion from another expert in the area. And obviously, consult with the client and let him know why you need an expert to come and either dispute this report or make a divergent opinion. In my practice here, I've seen that not many advocates use that avenue, and yet it is available. The other aspect of trial practice is that you obviously need to know, having studied the case file, the law that is akin to the matter in which you are handling. If it is a murder, obviously, that is easy. There may be cases like forgery of documents, cases where money is being transferred through digital through the computers. So you need to appraise yourself of all of this. Now, as a practicing lawyer, and to me I think this is one of the most important, that is cross-examination. Ladies and gentlemen, cross-examination in trial practice is a tool which will either make or unmake your case. A lawyer, whether you're a criminal practitioner or in civil, must master the art of cross-examination. Talks like this one may not give one what might be required, or what does one do to master the art of cross-examination. But I think, like they say, at the taste of the pudding is in the eating. So the more you do this, obviously the better you become. And of course, one must know that cross-examination, as I said, can either make or unmake your case. It's a double-edged sword. And if you are able to use it properly, it will make your case. There are a number of things one need to know, but the basic one in cross-examination is that put leading questions to the witness. Why? Because when you put a leading question, you obviously know the answer which you want. If you put an open-ended question, you never know the answer which the witness is going to give you. It might be against you, it might be opening another area which may damage you. So cross-examination should always be as a guide through leading questions. And it is always better that after you have analyzed the evidence of the witness, you already know the evidence of the others, it is good practice to jot down the areas where you are going to cross-examine a witness on. And please, when you are done, stop. And please, it is not always that you must cross-examine a witness. If a witness has not given evidence damaging your client, then you respectfully tell the judge, I've heard the evidence of this witness, my lord, your worship. With respect, I have no questions for him, you know. But many times I've heard lawyers have that feeling, that thinking, oh, if you don't put questions to a witness, then the client may think that you have not represented him fairly. But it is you who is in charge. And obviously, you need to let your client know that whatever you are doing is in his best interests. The other aspect also which I've either noted or heard from some counsel is that when you start cross-examining a witness, you have to be very forceful, threaten him or her, you know. But for me, I don't think that is the way. You have to look at the witness, gauge him or her, try to be humble. When you are humble to a witness, the witness will calm down and maybe think that this man is actually a good man, without knowing that the questions which are going to come will damage her or him. So you don't have to be forceful and threatening, you know, kind of. No, take it easy, you know. The witnesses are also human beings. They react according to how you face them. So please always bear that in mind. Now, lastly, as a defense lawyer, I think you need to have, for me, what I call a case manager. So what is a case manager? A case manager, in my view, in my own practice, is somebody, my assistant in the case, with whom I'll sit and analyze the case. Then I ask him or her to be the lead, not in court, but as far as we sit to discuss. He will know, we devise a strategy. There is this element of the offense to be proved. Which witness from the disclosures will be brought to prove that. Then we identify those witnesses. So the case manager will be the one to do that. And then obviously, he will devise, or you sit with him, how do we tackle him? Then you come up with the areas cross-examination of this witness. Do we face this witness and use him against this other witness? This is the role of the case manager. And obviously, at the end of it all, he's also been in charge of getting the authorities to be used. What was said in this case, how can we use it in this case? Can you pick this, use this in cross-examination against this witness? And yeah, at the end of it all, the case manager, to me, is a very useful tool in my practice. So, ladies and gentlemen, in a nutshell, this is what I can give in the short time that I have this morning with the ULS. I thank you for listening. If there are any questions, I'm more than ready to take them. Thank you.
Thank you very much. Wow, very brilliant insights. Ladies and gentlemen, he was right within time. We are going to take questions. We are getting to the Q&A from the audience. I have seen some through the chat. Mudumbusi Daniel, kindly prepare to unmute so that you can raise your question. But in the meantime, there is a question in the chat, Mr. Kabega. It comes from Councillor Senfuka Robert. He says, I have a situation at Buganda Road where a magistrate records her evidence on a laptop, and I don't trust that she will not edit the record of proceedings given her conduct. We have consistently asked for the record of every session, but the magistrate has refused to generate one for us. He adds that I believe that Mr. Kabega and his worship Timothy can properly guide me on this, because I have seen magistrates editing records of proceedings before to the detriment of the accused. Would you have a comment on that?
Eye for eye, the first thing I would do is to ask her worship what she has put down. Your Honor, may I, for my benefit, know what the record reads like, you know? And then, obviously, she has to oblige and give you what she has put down. And if what she has put down is not what you think the witness said, then you can challenge her and say, but Your Worship, for me, this is what I've heard this witness say, you know. If the magistrate still insists that this is what I have, then you would respectfully ask, can the witness be asked to give us a clarification on this matter? Maybe our worship can add something there.
Thank you. Is Mr. Mudumbusi Daniel online? Okay, I have been advised that we could be having an issue. Kindly, Daniel, please type your question. Type your question. There are questions that have been dropped in the chat. Let me get to the chat. This is a comment, I believe. There is a professional ethical matter where a client brought an advocate to the law council that he didn't represent him well just because he did not ask questions in cross-examination. So, I think that was the comment. So the question is it in cross-examination that you ask leading questions, or it's in examination in chief? I request for some clarification. And this is Mr. Mayora Crispus.
Yeah, obviously leading questions are not allowed in examination in the chief because they suggest an answer to the witness. But leading questions to cross-examination is the way to go. So the court cannot refuse you from putting a leading question in cross-examination.
Thank you very much. I will have 3 more before we jump into the next session. But Mr. Semfuka Robert, I believe, is online. He has said that Mr. Kabega has avoided my question. He has said that the land magistrate refused to disclose. What should he do in the circumstances? He refused to disclose the record. He asked for the record. He does not trust that he not edit it, but she has refused to disclose what is on the record up to now. She's avoiding. So he's wondering what should he do.
I believe in a situation like that one, I don't know whether the magistrate is a chief grade 1 or a chief magistrate, but I believe if the magistrate is a grade 1, then you lay your complaint to the chief magistrate. If it is the chief magistrate, then you put your complaint to the chief registrar of the High Court so that that matter can be resolved. For me, that is how I would handle it.
Okay. Okay, thank you very much. Daniel, I advise that you type your question here. Please keep it brief. Then Mr. Buchiro Agre, he says, good morning. What remedy do I have for a client who is incarcerated for 2 weeks at the police and an application for mandatory release is denied by the Chief Magistrate Court?
For me, what I would do is to put my application to the High Court.
Thank you very much. I have one from me as well. Land Council, have you been shocked by a decision before of a judicial officer where, given the evidence that has been given, you feel something went wrong along the way? You feel you've handled your case to the best of your ability? You feel you've given the judicial officer everything that he requires to give, to acquit as a defense counsel, but somewhere, somehow, there is a conviction?
Yeah, obviously, if you feel that an injustice has been done to your client, the only remedy is to go to the higher court. You don't confront the judicial officer who gave the decision, but just take your matter to a higher court, and I believe there you will be vindicated.
All right. Thank you very much, Mr. Kabega. Ladies and gentlemen, what Mr. Kabega has just shared reminds us that excellence at the bar is deliberate, and it requires preparation, being ethical, and being strategic. Ladies and gentlemen, please help me appreciate Mr. Kabega for the masterclass that he has delivered today. Thank you very much, sir. We hope to catch up with you again. Have a great morning.
Thank you, Isaac, and thank you, the audience, for having me today. Thank you.
It's okay, let me have it. Okay. Yes. Yes, ladies and gentlemen, we are welcoming our next speaker, Mr. Kamba Hassan. He's known for bringing fire to the courtroom. He's from Praxlex Advocates, 2024. That was 2024. To Rinawe Kamba and Company Advocates between 2013 and 2024. He lectured at the Law Development Center between 2011 and 2019. The areas of expertise that he basically handles to the best of his ability is criminal law, and that is why he's here today, election practice, commercial practice, and land transactions. He acquired his Bachelor of Laws degree in 2002. He's a holder of a Master of Laws in Oil and Gas in 2014. He's an advocate of 21 years of standing, a very rich experience. Ladies and gentlemen, please help me welcome Mr. Kamba Hassan. You're welcome, sir.
Thank you very much, Mr. Moderator. As introduced, I'm called Kamba Hassan, and my brief bio has been given. I want to wish everybody a very good morning today. I'm handling a very general topic, criminal appeals generally, from magistrate grade 2, those who still subsist, to the chief magistrate, from magistrates courts to the high court to the court of appeal. Some have constitution undertones, and from the court of appeal to the apex court of the country, which is the Supreme Court of Uganda. I cannot deceive myself that I can ably dissect the entire appeal process in a great detail, and I believe there is no time for such an elongated discourse. However, what I'm going to give are key highlights pertaining appeals or concerning appeals in our appeals judicial system, the appeals judicial system. And I'm perfect. I know that by the end of the day, at least a thing or two, we shall share a thing or two under the very widened theme. I'm not going to define what an appeal is. Those who want can read Justice Odoki's book. I think he has one book. But I'm going to state that the purpose of the appeal system is to enable higher courts to correct mistakes of lower courts which caused a miscarriage of justice. And this is very key, because not every mistake committed by a court will give rise to an appeal. In one of the cases I remember in Jinja, when an appellate court, a court of appeal sitting one of the grounds of appeal was that the Land Trial Justice had in law in changing the sex of the accused person. Instead of saying he was saying she. And somebody argued for almost 30 minutes wanting to put across such a question. The question is, did that mistake occasion a miscarriage of justice? There can never be an appeal against a conviction in a criminal trial where the accused was convicted on his or her own plea of guilt, except where the guilty plea was unequivocal, or where the appeal was against sentence, or where the appeal is against sentence. And the case in point is Varije versus Uganda, Court of Appeal, Criminal Appeal number 46 of 2014. Those who want to find it online, it is 2014 square bracket UGCA, Uganda Court of Appeal 43. It was decided on 11th November 2014. The court in the above case held that an appeal is a creature of statute, and there was no law that granted the right of appeal against a conviction on a plea of guilt. It is important to note that appeals in criminal matters lie against final orders, of the deciding case. Now, you will find that most people raise objections against the charge sheet. You find that maybe there was no evidence at all, but the magistrate or trial judge has found that your client has a case to answer and you are not satisfied, and other irregularities, like in the case of Uganda versus Chris, I've forgotten the Chinyankole name. There was an argument that the presenting of, it was before Justice Erubu, it is this year, at Haire, Chris at Haire. There was an argument that before URA computer-generated documents could be tendered, merely photocopies, by the way, could be tendered in evidence, there was a need under the Electronic Transactions Act to verify the what is the correct word used, the authenticity of the documents by a witness giving the background as to how they were generated. The judge agreed, but he held that the presumption is that they are correct, and it is up to the accused person. It is upon the accused person to rebut the presumption. And we said this is wrong, because an accused person has no duty in a criminal trial to prove themselves innocent or to disprove anything. They might even keep quiet, but we couldn't appeal, because why? In criminal matters, you appeal the final judgment, so to say. The case in point, there are several. Charles Harry Twagira versus Uganda, and you'll find many people still appealing these things. Charles Harry Twagira is Supreme Court Criminal Appeal number 27 of 203, square brackets 205, Uganda Supreme Court UGSC 14, decided on 3rd August 2005, where the court first of all said that the Supreme Court does not entertain under Section 5, subsection 5 of the Judicature Act, third appeals, from Magistrates Court except with leave. But it also held that there can never be no appeals can be allowed from interlocutory rulings of the no appeals against rulings of the Chief Magistrate or Grade 1 courts or even the High Court were permitted to come to the Supreme Court in the first place. The Magistrate Courts Act also restricts, in Section 204, restricts appeal in criminal matters to final judgments. However, there is only one case on revision. A party might seek criminal revision to the High Court under the CPA. Although now several decisions, recent ones, like Nanchindu versus Uganda, can just go online. It is there, it is from the High Court at Jinja. It said even revision can only be against final judgments. And there are errors, pre-judgment errors, like where charge sheet is utterly defective, somebody is being charged with a non-existent offense, and once the magistrate or judge says we have to proceed, and you have seen in the BCJ case where they say, the penal code says, where it deals with offenses committed within Uganda. And somebody says he had a gun in Kenya, but the judge says the trial must proceed. You can't appeal that. You have to hold your fire until the final judgment is made. So, the laws applicable to appellate practice in criminal matters, I'm now going LDC style, and you will forgive me. Laws applicable before you engage yourself in the appellate process is the Constitution, Articles 286, 126, 2B, 103 to 132, 2. You will read about them. That one talks about appeals to the Supreme Court, and the Judicature Act, especially Section 5, appeals to the Supreme Court in criminal matter. Sections 10 and 14 on the jurisdictions of both the Court of Appeal and the High Court appellate jurisdiction. The Trial and Indictment Act, it was Section 143, I don't know whether it has changed. The Magistrates Courts Act, I've said Section 204, following. The Criminal Procedure Act on appeals from Magistrates Court, Criminal Procedure Code Act on appeals from the Magistrates Court to the High Court, the Court of Appeal, the Supreme Court rules, Rule 66, which is the equivalent of 86 in civil matters, which provides the mode and contents of a memorandum. This is very important. You read so that you know that a ground of appeal should not be fluid, but must strictly outline the point complained against and the error committed by the judicial officer against whose decision you intend to appeal, and there are several judgments on that. The Judicature Criminal Procedure Applications Rules, when you want to apply for bail on appeal and so forth. Practice Direction number 2 of 205. This is important. Some people go to the Supreme Court, and even the Court of Appeal has those practice directions, and you are filing submissions, or you don't know how to apply to file for written submissions. Some people hate oral submission because of the engagement with those senior and personnel at the Apex Court. They will engage you thoroughly. You will be on trial yourself. Until one time, one of the lawyers, I don't want to mention names, when he was being crucified, what about this? He said, your lordship, let the real accused person, the apparent here, also engage himself in there. Because he was also in the lower court, He should maybe be able. So practice direction number 12205, presentation of submissions and arguments in the Supreme Court. And the PD, practice direction number 4205, the equivalent one also in the Court of Appeal. And case law. Before one appeals, especially on first appeals, he or she must ask themselves the following key questions, which I've summarized for you. Does my client have a right of appeal? That takes us back to Twagira versus Uganda 27/203 Supreme Court Criminal Appeal. But the best decision, if you want to read, is the Court of Appeal decision in that matter, which was confirmed by the Supreme Court, Charles Sare Twagira versus Uganda, which gave very detailed reasons as to why one should not engage themselves not to appeal against interlocutory matters or rulings in a criminal trial. One, because there are no statutory provisions respectively, both in the Magistrates Courts Act and the High Court TIA or High Court legal regime, which allows such interlocutory judgment. So, does your client have a right of appeal? That one, you might have a right of appeal. And secondly, are there errors of fact or law disclosing any grounds of appeal? When you are reading a judgment for purposes of appeal, I remember at LDC during our year, they gave us an appeal which had come from the magistrate grade 1, and they wanted an appeal to go to the Supreme Court. So you must weigh, what procedures should I take? Is there an automatic right of appeal? Is there a need for leave under Section 5 of the Judicature Act and so forth? You understand? That deals with that, because there are matters where you don't appeal directly, but maybe you first pass through, especially in the UR legal regimes, those court-martial matters might need to pass from the unity court-martial to the general court-martial and so forth. So, is there a right of appeal? 2, are there errors of fact or law disclosing any grounds of appeal? This is very critical, and that is because that is the backbone of appeal. It is either an error of law or fact. As we shall come to see later, we are going to highlight them. Then 3, did the errors of law or fact occasion a miscarriage of justice? Are we together? Did they occasion a miscarriage of justice? A miscarriage of justice refers to an unjust outcome. Did the error of fact or error of law lead to an unjust outcome to the accused person? Some examples of errors that result into a miscarriage of justice: for example, conviction of an innocent person as a result of a fundamental defect in the process, failure to sum up to the assessors, failure to swear in assessors, mostly from High Court to Court of Appeal. Those are things you pay attention to, because they are decisions. If the assessors are not sworn in, then the trial is a mistrial. Failure to evaluate evidence empirically. Maybe he left out key evidence which would have exonerated the accused person or the appellant. And when you are at the appellant stage, stop using the words prosecution and accused. You must either in your oral or written submissions restrict yourself to the appellant and the respondent. When you use the accused, it will mean that you are still half-baked as far as appeals are concerned. I was at failure to evaluate evidence. Obvious errors of fact or law, so far as I have read the Ugandan cases and jurisprudence on appeals, I can summarize them. According to Wikipedia, which is true even in Uganda, studies have shown that the main factors contributing to miscarriage of justice are eyewitnesses, that is eyewitness identification. So look what, was there a need for identification in the evidence to place the accused person on the scene? And how was, then you go to Uganda versus Nabulede. Those, what constitutes a good identification, a process, a lawful identification process. Secondly, faulty forensic analysis. Like I've given you the case of Uganda versus at Haile Chris, where there is a false forensic analysis. Maybe in the forensic analysis, the ballistic expert, it is coming out seriously during cross-examination of a very prominent criminal case, which I don't want to mention for purposes of the sub judice rule, but it is too much in the newspapers. The entire proceedings every day after they are published in the next New Vision and the cross-examination. So, faulty forensic analysis. How did you handle, were these items being analyzed by the forensic expert? First of all, put in exhibit slips. Do they tally with what is in the exhibit slips? You get the point. You remember that, I don't want to go into that, Uganda versus Kizza Besigye. It turned more on that analysis, because when they brought the station diary, the offense which was entered was obtaining money by false pretenses, or MBFP. Then there was a scratch and there was uttering a false check. And they had used that station diary and CRB to create this rape case. And the rest everybody knows this is a celebrity case. And if you have not read it as a criminal law or criminal law lawyer, then you need to visit it. False confessions by vulnerable suspects. Look out to these. Mostly appeals from anywhere, but mostly from the High Court. How was the confession? Do you know the law about confessions? Was the confession statement translated? And those other matters which make a confession. Was it made by a person of the rank of AIP or IP and above? Does it suit the description of what, and the law? Because now we have plethora. The jurisprudence on criminal matters in this area is well settled. False confessions by vulnerable suspects, perjury, lies, and inconsistent testimony by witnesses. Is the inconsistency in the evidence so contradictory that it goes to the root? Again, don't look out for simple contradictions on date, time. Those ones the courts have held so far that those are minor and not major confessions. Misconduct by prosecution or judges. I'm going to give you an example of two cases. In the case of Zungu Dennis versus Uganda, it is reported in 208 HCB, but when you enter Zungu, ZUNGU, Dennis versus Uganda, the High Court judge in Mbale, Justice Mwanda by then, was very compassionate about gender issues. So it was alleged that a child of 6 years had been defiled by the accused person, Zungu Dennis. And when the victim came to testify, a younger girl of by then now 7 years or 9, the judge felt compassion. When they asked the girl, oh, what happened, she kept quiet and started crying. And the judge said, you are free to go. And because of anger, of the gravity of the offense, said, I convict you and sentence you to life imprisonment. Without giving the accused person, without taking into the accused persons to a right, without even finding that there was a case to answer in the first place, without putting the accused on defense or not, convicted the man. So when we came to appeal, in the Court of Appeal, that was 206, 207, after arguments, after 3 minutes, the judge said, no. State, do you oppose this appeal? Do you oppose this appeal? And there is a very detailed decision you will read. And the other case I want to give you is Herbert Kenya versus Uganda. It is also online, Court of Appeal. The victim did not testify, the victim of defilement. I was representing the appearance in both of these cases. The victims did not testify. The key witness had said, I brought the case because the man failed to pay me, as we had agreed, to pay over those cultural things of Uganda, that he had to pay for removing Mbuzi from their daughter. Mbuzi, I don't know whether that is breaking the virginity, from their daughter. And the judge convicted the man, unfortunately. He was convicted for defilement. So when we reached, this was considered. But Zungu Dennis also has a very key and novel holding on experts, misconduct by experts. The expert just came, and the judge asked the lawyer, why do you object to, we shall come to that. Why do you object to the doctor's report? You can challenge it in submissions. And the man admitted. But the report was hollow. It did not show the basis, scientific basis, for which the doctor had reached the conclusion that the girl was actually young. So we raised several exculpating presumptions. We said the girl might even have been overage. That's why they feared to bring her in court. And now here is the man who was convicted. The expert, in fact, it was misconduct. Because he just said, I have examined using my naked eye, the girl is of a younger age. What is younger age? We ask it on appeal. A youth, the youthful age by then would go up to 34 years. You would be a youth. So the Court of Appeal agreed with us and did look also out and did acquit the accused, the apparent, on appeal. Ineffective representation by counsel. In the case of Joseph Kawoya versus Uganda, Supreme Court Criminal Appeal number 50 of 1998, the accused raised and said, the way this man is representing me, even the court noted and said, are you comfortable with the way the lawyer is representing you? And when you read, there was an article by, is he representing you well? And the accused said, even the lawyer was given to me on state brief. I have never seen him, I've never instructed him. And the man was convicted, and the Supreme Court held a bad lawyer is a ground of appeal. So how do you determine that the lawyer was bad? If they bring a witness and the lawyer asks one question, if they bring another witness, and key witnesses, and the lawyer says no question is in cross-examination, that is the first pointer, the first serious pointer to you showing that the lawyer is not up to the task, and it can be a ground of appeal. When you read that case diligently, you will be interested in finding what constitutes a bad lawyer. Because of time, I will not go into details because I know this is a session for very senior lawyers. The nature of evidence, is it by a child? Who is testifying? What is the nature of evidence? If it is by a child, what are the procedures, voir dire and so forth? You get the point. And other nature, or is it circumstantial evidence? Is it evidence which requires corroboration? When you read all appeals to the superior courts here in Uganda, that is where strong appeals, those are the areas through which strong appeals have been won or through which matters. Second appeals are governed by Section 5 to the Supreme Court and 6 to the Court of Appeal. On second appeals, on first appeals, whether from Magistrates Court to the High Court to Court of Appeal, you only raise grounds on mixed law and fact. The land trial judge add in law and fact in failure to hold. General grounds like the land trial judge add in law in failure to evaluate evidence have been dismissed under Rule 66 of the Judicature Court of Appeal rules directions. Have been dismissed. So you must specify. But when it is a second appeal, it is on pure points of law. The land trial judge, the land appellate justices add in law, in failure to, Although, and that's Rule 66 of the Court of Appeal rules, Section 1, I think 43 of the TIA, Section 204 of the MCA, and so forth. In the case of PC Wabwire Anthony versus Uganda, Court of Appeal, Criminal Appeal number 0052 of 209, a very recent case, it was held that a second appeal which raises matters of mixed law and fact was incompetent. On second appeal, a second appellate court is precluded from interfering with the concurring finding of law and fact by the lower courts unless the finding is based on no evidence, is a perverse finding, or involves a misreading of material evidence, or if there is a substantial error of law. In the Indian case of State of Rajasthani, Rajasthan and others, that is the State of Rajasthan versus Shiv Dayo and others, this is 2019, TMI, Volume 8, TMI 1793. It is the 793 is the page, not the year. It was held that a concurring finding of fact is binding unless it is pointed out that it was based on no evidence, etc. That for a concurrent finding of fact to be assailed in second appeal, the appellant is entitled to point out that it is bad in law because it was recorded the host. To record the host, what somebody was asking here, if the magistrate removes the record and so forth, recorded the host of pleadings, or it was based on no evidence or on misreading of material documentary evidence, or it is against a specific provisions of law. For appeals against sentences, I see you are looking at me in respect of time very seriously. I don't know whether I still have time. Appeals, for second appeals, you must know that for second appeals against sentences, you must know that for you to appeal against a sentence, you need to, I think, read the case of, which summarizes all the Supreme Court decisions, the case of Nabaya Peter versus Uganda, criminal appeal number 60 of 2012. I want you to read this case carefully because it was decided in 2013, and that talks ill of our appellate process, that somebody can appeal in 2012 and his appeal is heard and determined 11 years later. And in this case, the trial, it arose from criminal case number 107 of 2010 at Imbale. In that case, the justices of appeal, the Court of Appeal, did hold, citing very many other decisions. I want the holding. It is a very brief holding that that the appellant is entitled to have the appellate courts on consideration and views on evidence as a whole. Okay, that's not what I want. That the appellate court is not to interfere with the sentence imposed by a trial court, exercised its discretion lawfully, which has exercised this, unless the exercise of the discretion was unlawful or is such that it results in the sentence being imposed to be manifestly excessive or so low as to amount to a miscarriage of justice, where the trial judge ignores to consider other matters being to be taken into consideration. Now, by 2011, that arithmetical deductions of years was not in place. So you will find they will give you a criminal brief in the Court of Appeal of a 209 matter. Then you will say the land judge had in not removing the time spent on remand by the appellant. That will be wrong. But this case says that after 2011, by the decision of by the Supreme Court decision of Chizito Senkula versus Uganda, that is where now actual reduction. Before they were saying you take into consideration the time that accused has spent on remand. And once the judge or magistrate said I've taken into consideration the time, any sentence would be lawful. But now it is an arithmetical deduction of years. I rest my case.
Wow, wow. Thank you very much, Mr. Kamba. There are questions in the chat from the members who are watching us online. I think let's begin with Goreth Ayebare. Goreth Ayebare. He says, thank you very much. I hate paying bribes to clerks. I have a criminal appeal to the High Court, and the Chief Magistrate Court is taking forever to avail the record of proceedings. We have made complaints to the Chief Magistrate and have not received any assistance. What should he do? Or what should she do?
There is not receiving a record. You see, in appeals to the High Court, I would advise him to write to the Deputy Registrar of the High Court Circuit, which is going to appeal, for the Registrar to write now calling for the file, or going with the High Court. Yeah, my answer would, or advice would be that He should write to the registrar of the High Court Statute, because the registrar of the High Court Statute is also the inspector of courts in a given statute, in all magistrates' courts in that statute. So when you write, like we do in civil appeals, you will say, I have tried to get the record of proceedings and they are not forthcoming, and maybe they are being doctored. I therefore pray that the High Court calls for the file with the typed proceedings to the to the High Court to enable me file my process. And practically what you do after you have written, you go with you get the letter calling for the file, and you go with the clerk of the High Court to pick the file from the magistrate's courts.
Thank you very much. I hope Council Goreth Ayebare, you have gotten something from.
Please don't bribe. But there is one case on bribery, and now several cases in the Court of Appeal. What now people are doing when people have been in custody for a long time? There was a matter where the High Court record disappeared, and I think deliberately. And Justice Egon and Tende, I don't remember the parties, did dismiss that appeal for want of what, which I think was not very good. So what people did from then, several files disappeared from the High Court. Several High Court records in the criminal matters, they stepped on the brake pedal, and they were inquiring, what should we do? When somebody steals the file from the lower court, and your client was convicted, painfully, maybe he has been he has been on committal for 10 years. Painfully now, what I think they are going to do is to order that to order for a retrial, that maybe he gets a mandatory bail and then undergoes his retrial. Those things are coming up of bribing. So lawyers, please let us save face.
Thank you very much. Mr. Kamba, I would like to pick your comment on Tumwesije Lewis's question. Yes. He says, a magistrate grade 1 in Machin, Standard Utilities Court, that is how he writes it, always advises accused persons to abandon their lawyers, reminds them for longer periods, and only grants bail when advocates are told by relatives of the accused not to go back to court because they are incompetent. Then he adds, this is done, I think, in open court. That is what she's saying. Just a moment. I want to finish this question. Yes, it's done in open court. What do you have to comment about that?
That is what, when I made my presentation, I said one of the is misconduct by judicial officers. These days we have recording gadgets, because now the question would be evidence. How would you prove that he said that in open court? When you remove your phone, it would be contemptuous of court. But what the magistrate is doing is not only wrong, but utterly unconstitutional. Because under Article 28 of the Constitution of the Republic of Uganda, every accused person has a right to an advocate or to representation by a lawyer. That scenario arose in Arua, in Gulu, the case of Alenyo versus Uganda. It was an assault court. The chief magistrate, whom I don't want to name, is now a judge. The chief magistrate called the clients and said, why are you wasting money on a useless man when you can bring that half of that money? And you see, I'm the one with the pen. I am going. This is true because it is on record. The case is a case of record. Alenyo. Is it Alenyo Joju? Alenyo somebody versus Uganda. So what the clients went and said, we are here to tell you that we have got a quick relief. kindly forgive us. He said, what happened? The magistrate has told us A, B, C, D. So what Alenyo did, he went and he boxed the chief into Parup actually. So the matter was taken to Law Council for beating the chief magistrate, and he was, I think, deregistered as an advocate. What is the correct word? De-enrolled.
Disbarred.
No. He was removed from the role of advocate. So he made several constitutional what, and I think he failed. But I think you should write to the powers that be. You can complain to the Judicial Service Commission. And say this is happening. You can complain to the CJ, to the deputy CJ, to the CJ. One time there was a magistrate in Tororo, 207. He would come at 2 and do the same thing. He would first do a puzzle. I don't want to say his name. He was my friend, although not for bribery issues. So what happened, because when he would fail, when I'm there to fill in puzzles, I would fill the rest. So what happened, they complained to the Inspectorate of Courts, and the judge in charge was Justice Namundi by Justice. There was this judge who was a Mugisu, who was at the head commercial court one time. I forget his name. So the judge went at 7. But I think somebody tipped off the chief magistrate. So when the judge went, he found when the chief was seated at the gate, he says, these cracks come late and they report to me. So the judge said, fine. After 2 months, the judge went now and sat, and the big man came at 2:30. He found the judge said, I've been here. I think he was retired in public interest. So advice to the lawyer, you complain. This is something you cannot keep quiet of. Justice Muhanguzi one time called me in his chambers and he said, I know the registrar has done this to you, but if you don't complain, you are killing your own profession. Complain and get no results, but go on record that you have complained.
Thank you very much. I would like to also pick your comment on Mr. Mudumbusi Daniel's question. He says his concern is about the growing practice of judges to ask questions to witnesses after re-exam. And he adds that most judges ask questions to damage their cross-exam. What do we do as a defense?
That thing has brought me problems. I first want to give my experience. Why people used to say Kamba is this, Kamba is this. We were in Masaka in an election petition before a judge who is now very big in the judicial system. And I think there had been a RDC with the respondent in the petition. Our petition was premised on 3 grounds: academic qualifications, failure to do a mandatory recount, and violence in the electoral process. So when I first want to give my experience, then I will answer on these judges' questions. So when the witness entered the dock, the witness now is a former minister, I asked him very ordinary questions. You say you did your A-level at Wakakoma somewhere. And he said yes. Was this a boys' or girls' school? He said, I have hobbies here. This was a boys' school. Then I said, but your certificate shows that you sat from a girls' school. Then the man kept quiet. Then the judge said, you say you sat there as a private candidate. So the witness said, yes, I sat there as a private candidate. So I asked him, you say you did the chemistry. How many papers did you do? You have brought your academic papers, originals, we have them. How many papers did you do in chemistry? The man said 26. Instead of the judge writing, said, no. Your papers are showing, your academic are showing 3 papers in chemistry. Said, oh, I did 3 papers. Then the judge wrote his own answer. So, but I don't want people to do what I did. So when I asked, name any one of them, the man said, broken glasses. People laughed, meaning the man had never studied anything in chemistry. Then the judge said, oh, it is practicals where glasses break. Then the judge, so I said, your lordship, I want to protest in the strongest terms your conduct. What you are supposed to do, take the witness's answer, then at the end, if you want some clarities, you can ask. Even if he contradicts himself or he says something better, it is good. But now you have turned yourself into a witness. Yet you have not taken any oath for me to cross-examine you. The judge said, I'm going to arrest you. I said, yes, under Rule 11, you are entitled to arrest me, but put my complaint on record. So the judge was courteous. He called me in chambers, and he told me that, what do you want? I have this man is my man. I was RDC with him. I was in Changkwanzi. Should I say him? I said, all the best to your lordship. And I lost that case. The thing continued. When does a judicial officer ask a question? Some take over, like we had His Worship Mudas. He would now prosecute the case together with the state. The state asks one, the chief asks one. This is not acceptable, although they are entitled, but how do they do it? Is to seek clarity. When you said this, what did you mean? You get the point. So you courteously, so people started saying, he was assuring the judge that he's wrong, so Mr. Kamba exchanges with but that was not the case. Actually, it was very painful because we were losing a case because of the judge. Even UNEB had written saying that the man's papers are fake. So when we brought to Kenya, the judge took over. Before we started, even because is ready for crosses. Hey, Mr. Kenya, you know you are my friend. You are my friend. These things happen. Maybe you made the affidavit wrongly. You know when we were in the other case. So my witness broke down. You know, secretary. He said, okay, it is true. It is true. Let us go and find out whether the papers are genuine now. When they went, when we came back, I said, they are genuine. Then I now applied to cross-examine the secretary, Mr. Kenya, as a hostile witness. And he repeated what he said in his affidavit. The truth is, they are fake. So this is not acceptable. But it happens to all of us without exception. And maybe I'm not going to say, maybe some do it innocently, and some have a background of being lawyers. You understand? The judge was an advocate, and maybe seeing somebody is not doing his work, he has left this question. It is not proper because it borders on bias. But now the danger. We were before judge, and we said, Your Lordship, we apply to put our recording gadgets on record, and the judge allowed us. Then he stopped asking questions totally. So I think this is a general problem, asking questions by judicial officers, not very many of them, but a few, mostly at the magisterial level, do this very rampantly. And you object politely and courteously and say, Your Lordship, we request that maybe he finishes or I finish. Then at the end, the court can come in because it is entitled to ask legally. But what to ask? To seek clarifications from evidence because it manages its record. Thank you very much.
Thank you very much. Our time is actually fast spent, but in 1 minute before we invite in our next panelist, there is this comment from Patrick Asiku. There are some judges who grant bail applications filed by specific law firms and also read an indictment before the grant of bail. He says, please comment. In a minute, please.
They say when a rat lives so long, it can have the privilege of eating the skin of a cat. That they grant bail from specific law firms, I'm not aware. And I think I'm not competent to comment on that. But if it is happening, reading the indictment, it happened to me recently when I applied for bail. They said, no, the trial is beginning on 3rd, and so abandon your bail. I don't know whether when the trial begins, the accused person is not entitled. It was mandatory bail actually. But out of respect and courtesy, we must always be courteous to the judicial officers. Whatever mistakes they make, we should not kill the entire judicial system by being poky. I tried that, I've left it, I'm now saved. Whether you do what, whether you throw a bottle at me, I so obliged your Lordship, because when you grow old, you learn not to be combative, as it might come to haunt you at later years. Thank you very much.
Thank you very much, Mr. Kambasan, for the illuminating discussion. You have thrown light on the path from a conviction to appellate success. We have been so privileged to have you today. Thank you very much, members in the audience, for watching. We are still continuing. We are going to have our next panelist here. Have a wonderful day, Mr. Kamba.
Thank you so much.
Ladies and gentlemen, if there is anyone who embodies both strength and grace in public prosecution, it is Miss Immaculate Angutoko Dralu. She's the president of Uganda Prosecutors Association and one of the leading voices in strengthening the prosecutorial standards in the country. She's a seasoned prosecutor. She joined the office of the Director of Public Prosecution in 2005 and has since risen through the ranks to the position of Chief State Attorney. She's the president of, I have already said that, and that has been since 2022. Immaculate currently deputizes the Department of Research and Training at the ODPP, in which role she has coordinated and organized, participated in various training and capacity building activities for continual professional and skills development for prosecutors. She also coordinates activities of the ODPP Virtual Learning Academy. Immaculate has a wealth of experience at national and international level. She has prosecuted a plethora of criminal cases and appeals across the courts, from the magistrate courts to the Supreme Court. She is also passionate about seeking justice for victims of crime and has an outstanding appellate practice. She has also undertaken some international roles, and she has been the executive member of International Association of Prosecutors, IAP, since 2023 to date. She's a junior research fellow at the European Institute of Policy Research and Human Rights since 2023. She was the Judicial Affairs Officer with the United Nations Assistance Mission in Somalia between 2018 and 2021. She was visiting professional with the Office of the Prosecutor, ICC, between March to May 2018. Her education background is outstanding. She holds an MBA in the University of London. Actually, it's ongoing. Oh, you have since completed it? Oh, wonderful. She holds a postgraduate diploma in project planning and management from UMI 2015. She holds an LLM from International Law of Human Rights and Criminal Justice in Utrecht University in 2011. She holds a postgraduate diploma in legal practice that she got in 2005. She is a holder of a Bachelor of Laws degree from Makerere University in 2003. So from that, ladies and gentlemen, please help me and join me to welcome Miss Immaculate, and she's going to be discussing a very, very interesting topic, which is the complexities of criminal practice, navigating borderline cases from a prosecutor's perspective. And before I invite her in, I want to comfort Mr. Buwande Anthony. Your questions have been seen, but she's the right person to answer these questions, and I'll put them to her at the end of the session. Miss Immaculate, you're welcome, please.
Thank you very much for the kind introduction. In the interest of time, I will go straight to my presentation. But before that, I must say thank you to Uganda Law Society for the partnership in enhancing legal education among the members of the legal fraternity. And I'm really proud to be associated with it. So my topic for today is, as already mentioned, the complexities of criminal law practice, navigating borderline cases. Just a reading of it alone already highlights that it's quite a wide topic, and it's not clear as such. So for researchers, they would say that there is a problem with how it's framed, but I think it's on purpose. And at the end of the presentation, probably we would have put it into the right perspective. So as a criminal law practitioner, just like any other legal practice within the country, it's from experience that legal practice is very complex, and the prosecutors or prosecution itself is no exception to that. So I opted to approach this topic from a specific perspective of what borderline cases entail in regards to my presentation. I'm sure borderline again raised a lot of questions for someone who just read the topic, but I will shortly highlight what borderline is in regards to my presentation, and drawing from experience and jurisprudence, and then of course highlighting the roles of a prosecutor. So what do we mean, or what do I mean when we talk of borderline cases in the context of this particular discussion? Whereas there might be various definitions to what borderline is, people might have their own perspectives regarding what borderline cases are. My discussion will highlight two of those, but focus mainly on one because of time. I would have loved to expound on others as well, but I'll focus on one. So just in layman's terms, I would say borderline cases in this perspective refers to cases that have both a criminal and civil aspects or components. I'll also shortly highlight some more details about that. The second perspective is that cases with facts which disclose more than one offense. So as a prosecutor, many times you receive a file from police, you peruse it, and there is either evidence disclosing one offense or more, and now the decision is upon you, the prosecutor, either to charge, and if you decide to charge, what offense or offenses you're to charge with. So by way of example, in the first category, we have land-related matters, mainly. Of course, we have others, but it's mainly land-related matters. You find that many times ownership is in question. However, pending determination of ownership, whether they've taken any steps or not, but of course they all claim ownership, there might arise circumstances where seemingly crimes are committed, whilst the ownership is not yet determined. And this include, for instance, malicious damage to property. You have criminal trespass. Sometimes it's forgery or uttering of false documents. So there's a wide category of possible offenses or crimes that often are committed where parties are also claiming ownership, various parties sometimes. And this could be either the complainant and the suspects or a third party. So those scenarios arise, and that's now where the prosecutor has to apply skills in order to make decisions. The second category example I would give is that's where possibility of two offenses is aggravated trafficking under the Prevention of Trafficking in Persons Act. If you look at Section 3 and 4 of the same, and then you have aggravated defilement, which is under the Penal Code Act. So you could have also a scenario where you have received a case file from police, and the facts fit into both. So now the duty is upon you, the prosecutor, to make a decision as to which offense you're going to direct police to prefer against the possible suspects. And as you can see already from these two examples I've given, it already poses that it's complex enough, and that should speak into our topic of today. This therefore imposes a duty upon the prosecutor to navigate the blurred boundaries and legal complexities that arise out of land disputes or land conflicts, which take sometimes a turn towards criminality. And I'll then go to highlight the roles or the duties of a prosecutor in the scenario. Now, as a prosecutor, or as prosecutors, we play a very vital role in guiding investigations, and this arises from our mandate, our constitutional mandate, which is in Article 120 of the Constitution. Therefore, we have to direct investigations, and this should be overall. It should cover overall claims by both parties, if at all. At the end of our inquiries, the prosecutor should be able to carefully analyze the evidence that has been gathered, and not only reading one side. Of course, I know there is that tendency that, okay, I am for the state. I have, my duty is to ensure that criminals are prosecuted and all that, but that's not how we are supposed to handle it professionally. We are supposed to look at both sides of the story where it is a land conflict. And then from reading of both sides of the story, and then you can come up with a decision, whether you want to charge or not. And of course, that decision is guided by a number of factors, which I will move to in a short while. And also, as prosecutors, we have a role to direct investigations regarding the exculpatory facts. For instance, are there any defenses that are put forward by the possible suspects? If so, we have to direct police to investigate. One common defense when it comes to land-related matters is the defense of the claim of right, which is the Penal Code Act, I think Section 7, which provides that a person is not criminally responsible in respect of an offense relating to property if the act or omitted to be done by the person with respect to the property was done in the exercise of an honest claim of right. But of course, we must note that there is an exception to that. The claim of right defense does not grant impunity to criminals or criminal acts. It is vitiated once there is proof that there is fraud. Now, what factors should prosecutors consider when faced with such borderline cases? There are a number of factors. I will just also highlight a few. The first point for us as prosecutors is we have to look at the sufficiency of evidence. As we are aware, in all criminal cases, the burden is upon us, the prosecution. And this burden is, the standard is beyond reasonable doubt. So whatever case you decide to take to court, you must have some level of assurance that the facts you have or the evidence you have will be able to meet the standard of proof that is required of you. So to meet this requirement, the prosecutor should ensure that there is sufficient evidence on the case file before it is sanctioned for court. And this evidence we are talking of should not only speak to one ingredient. As we know, every offense has a number of ingredients. So you can't just say, okay, the suspect participated in the offense and that's enough, whereas the offense has a number of ingredients. An example would be malicious damage to property. It has a number of ingredients. For instance, there must be destruction or damage to property, and this must be unlawfully or willfully done. And then this property belongs to somebody, but it can also belong to the accused or any other person. And then participation. So if your file only has evidence enough to prove, say, 1 or 2 of these ingredients highlighted and does not speak to the last one, then there you should not take that decision to sanction. The best you can do is direct for further investigations, and now in specific regard to the ingredient that lacks sufficient evidence. Another factor that we would consider is the public interest. The interest of administration of justice and the need to prevent abuse of legal process. As we are aware that a number of times complainants might report cases for different reasons. And I can tell you, sometimes we are guided by the evidence, but you find that a witness can also be coached, that the statement really proves that an offense was committed. So our duty as the prosecutor is to ensure that the interest of administration of justice and the need, we prevent abuse of the legal process. And how do we do that? You must critically assess and analyze the evidence that's on file. If you see that there are certain loopholes, you direct for further investigations in that regard before determining whether or not to sanction a particular case file. Another factor is also, of course, we consider, whereas criminal cases are prosecuted by the state, behind the state we have victims of crime. You have complainants, you have the public, and witnesses as well. All these stakeholders have expectations as to how the case must proceed. So you need to be able to manage those expectations by sticking to professionalism and take your decision impartially. But of course, while doing that, we do not just disregard the interests of these other parties. For example, we know that in criminal cases, it's mainly to penalize. But now in issues regarding land, you can have a complainant coming to your office and tells you, you know what, state, my interest is that this suspect or accused person appears in court, is prosecuted, so that I regain my land back. But then you know that such a redress is not affordable in the criminal justice system. It has to be a civil suit for them to get such a remedy. So if it's about recovery, if it's about other interest determination, for instance, of ownership, the state attorney or the prosecutor cannot say that, no, I have read evidence of so-and-so, the LC1 and witnesses, and therefore I believe that, or I determine that this land belongs to the complainant or belongs to the other party. We do not have those powers. So we have to look at their interests. If their ultimate interest is that they gain ownership or ownership is determined, then there the best advice would be for them to pursue a civil suit. But we've also had cases whereby, of course, ownership is in question, but clearly offenses or an offense is committed. We've seen lots of these either on media or being broadcast in various TV stations, whereby, for instance, ownership is in question. Someone claims that they've bought the land and they are squatters who have lived on that land for several years, and they have interest and claim of ownership as well. But without regard to their interests, someone comes and evicts them without a court order. Is the expectation that because you're a prosecutor and this matter is about ownership, no criminal action should be taken against any suspects? We've had cases whereby there is malicious damage of property or forceful entry. So we have all those issues that we have to look into. Though another challenge in navigating is that sometimes people tend to misconstrue. They think that once there is a component of land, ownership comes into question, then the state has no right to sanction. But there are already offenses committed. For instance, if assault was committed during altercations, for instance, if property was destroyed where both parties were claiming ownership and the ingredients are there, would you expect the state to either sanction or to close it just because there is ownership in question? So those are some of the challenges. Therefore, it's very imperative to interrogate and establish the actual interest of the complainant, to know whether it can be achieved through the criminal justice system, or whether it's best suited through a civil proceeding. Further, therefore, what must a prosecutor consider while faced with such facts in the execution of their duties? The prosecutor is expected to look at the following. The first, as already mentioned, you have to look at the facts and then the offenses disclosed. As you read the facts, do the witness statements disclose any offense, or does the evidence as a whole disclose any offense? And that offense, remember, has to be created by law. If so, then it could be, you could make the decision to charge. Secondly, what if the offense is disclosed, like I mentioned before, what are the ingredients? If we are talking about malicious damage to property, for example, if we are talking about criminal trespass, for example, do those ingredients, are they present in the facts available already as per the investigations? That also helps. Another factor that, or aspect the prosecutor must consider is whether the facts at hand are able to prove these ingredients. As I said, these must speak to each and every ingredient, because the duty upon the prosecutor is to prove each and every ingredient of the offense. You cannot say, I have already successfully proved 3 of them, therefore it's not a problem if the participation is not, there is no evidence to prove participation. And then we also have to look at whether there are any defenses available from the facts of the case. For instance, is there any claim of right? Is the suspect denying? Total denial? Is there rights, the defense of property? Sometimes they bring that up. Is it defense of property? And if so, the prosecutor has the duty to direct that police also investigate those defenses. Why? Because that is going to help you to come up with a well-informed decision, instead of looking at only one side. But if both the defense and complainant's side have been properly investigated, then it will make your decision-making easy. Of course, there has to be evidence also in support of the defenses, though the burden is not upon the accused person to prove his defense, but in our analysis, then ensure that there is some evidence in helping you to determine. And so what does this entail for a prosecutor in their role of directing investigations or prosecuting criminal cases? One is that we have to ensure that exhaustive investigations are done by the police. Therefore, most times you have to direct and specific say go to visit the scene of crime, record a statement from the area authorities, take photographs, for instance, where there are claims of malicious damage to property. The scene of crime has to take photographs to show that indeed property was damaged. So you have to be really detailed when you're guiding those investigations. Most times now in the office of the DPP, we also have resorted to prosecution-guided investigations. And this helps in giving proper direction, like I said, whereby right from the start, the prosecutors work with the police, the investigators, to move together. And once you have conducted some investigations, you have midterm case conferencing to assess progress, to analyze the evidence so far gathered, whether you need to change direction, whether it's sufficient. So those are some of the steps that we undertake to make decisions. Then investigation of both claims, as I already said, we as the prosecution are under a duty to direct investigation of both inculpatory facts and exculpatory, meaning that evidence that pins the suspect as well as evidence that exonerates the suspects in a particular case. And of course, when it comes to our analysis, we are required to be objective without any bias, look at the facts as a whole without fear or bias, and come up with a decision. Of course, in doing so, we are also supposed to undertake extensive research. Now, you will know that currently, in this particular aspect of borderline cases, we have a number of contradicting cases, especially whereby the accused persons have come up to make applications to courts to stay proceedings where there is an issue of land or where they have filed civil matters. And it hasn't been very helpful. Like I said, there is contradiction in the jurisprudence that we have so far. So it's important that as prosecutors or even as defense counsel, we conduct extensive research while making our decisions at perusal level to guide us, because already we have case law that's conflicting on the subject matter. Now, it is not only us, the prosecutors, who have a role to play. We have other stakeholders as well. And for instance, today we are talking to the legal fraternity, we have the young lawyers, defense counsel, and all that. So each of us has a role to play. Does the defense have a role to play as well? Yes, you do. As a defense counsel, your duty, of course, is to diligently represent your client and your client's interests. But in so doing, you have to be aware that you are officers of court. So you also do not have to be biased. You have to be objective in providing legal advice and guidance to your client. You also have to be open to collaboration. Sometimes I get frustrated when I see on social media that a defense counsel comes with problems that could be resolved by simply contacting the state attorney or the prosecutor. They come and resolve it on social media. I think we should be open to collaboration, because what ultimately we want is the truth. It's not about I have been paid by the state to prosecute, therefore, by all means, this person must be convicted. It's not about the defense counsel receiving instructions from the accused person. Therefore, this case must be ended at the earliest possible, whether it's by way of stay and all that. So we should collaborate as officers of court, provide the relevant information to court, and we should do this professionally. We should all be open to extensive research. Something that I encourage both parties to do is I think we should help court in building jurisprudence. We have the issue of illegalities, whereby now for us it's a practice that where we see there is an illegality, we concede to it. So also as defense counsel, if you see that really there is evidence of a crime committed, whereas there is ownership and the matter is related to land, please concede and find a common ground how this matter can be best resolved. Instead of fighting just for the sake of it. It wastes a lot of court's time, it wastes a lot of resources. So if we collaborate and we guide court, and especially on matters of legality or illegality, then there we will be helping. Another stakeholder is courts. Like already I said, there is really contradicting jurisprudence in regards to whether you can have civil, criminal, prosecuted, ongoing at the same time. Of course, we have authorities, even of the Supreme Court, but there is still a challenge of judicial officers coming up with more contradicting decisions. So as stakeholders, our plea to courts is to streamline the jurisprudence so that we know that this is settled law, instead of having settled positions being unsettled at all times. I think I am done. So in conclusion, I would just like to say that the criminal landscape is full of complexities, among which we have the borderline cases that I've defined in my presentation. And therefore, it requires all of us, the prosecution, the defense, and the courts of judicature, to work together, put up concerted efforts to navigate these complexities. I don't know if I still have more time or I overshot. I think I'm still within. Oh, I actually still have some time. But that is all I had, unless there are questions for me. Thank you for listening to me.
Thank you very much for the wonderful discussion. Very many questions have been painfully lying here since the beginning of the sessions. And Anthony Mwande, your time is now to shine. He asks, my question is whether the accused can enter into a negotiation with the state, let's say on a matter of obtaining money by false pretense, and then present the consent before a magistrate or a judge and close the case, or whether it should be a plea bargain instead. And what happens if the accused does not live up to the agreement that that he made, yet he was released and the file was closed? Can it be reopened? I think it's a voluminous question. I am wondering if I should put the questions all to you and then you answer them at once.
Oh, one by one.
One by one.
I might lose
Thank
track.
you.
Yes.
Please.
Whether it's okay for the accused person to enter into negotiations with the state. Now, of course, all criminal cases are prosecuted by the state. That's Uganda. But like I said, beneath that, we have victims or complainants. Now, the MCA itself, section, okay, I don't remember it offhand, it provides for reconciliation. However, it's not in all cases. So those are offenses triable by the magistrates' courts. So I don't know if this was in specific regard to a particular court, but the MCA is clear on that. But even in the High Court, I've witnessed cases where the Court of Appeal itself relies on Article 126, I think, not E. There is one which provides for reconciliation among the parties. So they've relied on that also to promote reconciliation. So there are many ways of doing that. Negotiations, it could be through plea bargain. That's one. So I don't know whether there is a particular mode that the question was targeting, but plea bargain itself is a negotiation that it's a common practice now, and I think we have a presentation today about plea bargain. So yes, we do that through plea bargain. And then in magistrates' courts, I've witnessed whereby the complainants make additional statements, and then those are tendered in court, and the matter is resolved by court itself. But by the prosecution, I think we have guidelines that require that the matter comes to the DPP before that can happen.
Okay.
Yes.
Thank you very much, Immaculate. There is a question that is from Agre Bochiro. He says, Madam Immaculate, kindly be pleased to shed light in respect to section 208 of the MCA that speaks about stay of suits, wherein the same parties have a civil matter before the same court at an interesting time when their claim of ownership of land is not determined, and the plaintiff or complainant institutes criminal proceedings under the case of trespassing.
I already mentioned that we have contradicting decisions already. We have a number of jurisprudence. Now, I would like to address it. Section 208 in particular, I don't know what it's all about. I don't have my penal code here. I wish I could just read it maybe too. But I think the question is speaking to whether it's okay for us to sanction criminal charges where already there is a pending civil suit for determination of ownership. I would say yes. As a prosecutor, that's my perspective. Why? Because I just went through what considerations are to be there. I gave you examples of how, well, there is ownership in issue, but you find that this person deliberately goes to the land and either attacks, destroys property, and all that. And those are crimes already. The principle of legality says that the offense must be provided by law, it should be defined, and penalty prescribed. So if I've perused my file and all the ingredients of malicious damage to property are there, why won't I? Why would I not charge just by the fact that there is a pending civil suit? Yes, you're both claiming ownership, but that claim or the suit does not entitle you or give you a right to go and commit crimes. So yes, I would say you can, but of course it's a case by case. Sometimes also you find that it is the other party manipulating the system by reporting a case so that the accused person or the other party is arrested and taken to jail, and as they are there, they manipulate it. So really it takes us to a lot to peruse and go through what I just discussed in our presentations.
All right. Then there is Rubura Peter. It says Rubura Peter is attending this training session to earn 5 CLE points after paying his hard-earned 100,000 shillings. I don't share your pain, Peter. I think Miss Immaculate, there is a question from Patrick Asiku. He asks, in an assault case where the victim and the perpetrator injure each other, the perpetrator precedes the victim to police and records a statement. When the victim reports to police, they are not usually helped. How would you help such a victim?
Perpetrator and?
There is a victim, there is a perpetrator. They fight. They injure each other. One of them goes to police first. So when the other comes, he's not a victim anymore, he's actually a suspect. And how would you advise in such an instance?
No, in that case, I would expect that both parties report, regardless of who has reported first. We have what we call counter accusations or counter sister files. So if indeed you have fought or you assaulted each other And now it's counter accusation. What we do is that you encourage whoever feels that a crime has been committed or is offended, goes and reports. Bring your witnesses. And the witnesses record their statements as to how it happened. The other party will also go and record their statements as to how they perceive it happened. Now, what we do is when we have such matters, both those files move together. And we really have a complaints mechanism in the office of the DPP that I encourage the public to pursue, or even advocates to follow up. Because when you complain that, yes, I was assaulted, even if you had not reported, then we direct for investigations of your claim as well. In that case, we will have two files that come together, we peruse and see. If we find that both of you actually participated, we have the offense of affray. So we can charge both of you. But sometimes you find that it's actually one party that participated and the other one was simply quiet. So you really analyze the evidence and come up with a decision. So yes, you can handle such through counter accusations and perusal of both files.
Thank you very much. Anthony Buande says, Isaac, let senior counsel add whether the file can be reopened in cases of default. And then he says, magistrate court. Sorry? Yes. Yes, magistrate court to be specific on whether I then go civil. Remember, there was a consent signed, but out of a criminal matter. I think, I don't know if you remember the question that he had asked.
Yeah, whether reconciliation.
Yes.
So now, where parties are reconciled, usually for us to guard against any allegations, there is an additional statement. And your additional statement actually says that I have therefore lost interest in the case. And this is signed, it's recorded by police. So for you to come back later, because by the time you decide to make additional statement, it's expected that you have already resolved your differences. So if you haven't, I'm sorry, that might be a challenge. But if you've made additional statement, then I think you cannot eat your cake and have it. You can't come back and say, oh, I made it, but now they failed to pay me. Please sanction. If it were me personally, I won't reinstate such a matter. Yeah.
All right. Now, here comes a frustrated advocate, Miss Nwama Nyamorin. She says, can she talk about scenarios where the prosecution commits an accused even when there is barely enough evidence on the file? This really frustrates justice. However, it seems like the state must commit regardless of the weight of evidence. I hope she needs your comment on that.
I'm sorry about your frustration. I don't know if you have a particular case file or scenario where that has happened, because personally, I don't know about other colleagues, and I really think that prosecutors must commit where there is evidence, because it is section 168 of the Magistrates Courts Act. Your summary of the facts must disclose sufficient facts. So if you do not have that evidence, where do you get those sufficient facts to incorporate into your summary of the case while committing? So really, unless you have a specific file or scenario where that happened, we usually commit where we are convinced that there is sufficient evidence to commit.
All right, thank you. I happen to be handling the relevance of committal proceedings in the criminal justice system as my research topic at LLM.
Yes.
Surely I find the same frustration, because for the magistrates, their hands are tied.
Yes.
They just have to commit. They cannot take plea. They cannot hear a bail application. They can't do anything. Once you say these are the committal papers, they are ready, they just commit. I happen to feel that it's sort of irrelevant, but it's a subject of some research. Anyway, I think I will ask this. Patrick Asiku asks a very specific question here. He says, how do you handle tendering in evidence of a report of an expert who has died? I don't know if you can help him.
Section, okay, it's in the Evidence Act, whereby another party can tender in their evidence. So what you do is you simply have to call a medical expert, okay, another expert in the same field. So I don't know whether it's a medical expert, handwriting expert. You call somebody who is conversant with handwriting and workings of the deceased expert. And then, of course, in your opening questions, you have to ask those introductory questions as to his qualifications, whether he's conversant with the workings of the deceased, whether he can identify the signature, the handwriting, and all that. So it's allowed, but you have to inform court and also cite the law. It's in the Evidence Act. I'm sorry, I can't get it off head, but it's provided for. We've done that a number of times with medical officer, and it doesn't have to be only when the person has died. It can also be where you can't immediately find that particular expert to tender in. Court allows that.
Wow. Thank you very much. Now, I also have another one.
Yes.
Miss Immaculate, I have realized as an advocate that there are very many lies told inside the courtroom under oath. Mm-hmm. I have not seen a commensurate effort to prosecute perjury, yet it's in the Penal Code Act. Is this intended? Is it ignored? Why?
Perjury is in the Penal Code Act. But how are you going to prove that it's a lie? That's another thing. Well, what you perceive, it depends on which side you're at. So what you perceive as a lie may not necessarily be a lie. Sometimes witnesses are not familiar to the environment. So as you're asking all those questions, they keep contradicting each other. Yes, sometimes, indeed, it comes out to be a lie. But now, if it comes out to be a lie, who are going to be your witnesses when you go for perjury? You're going to call the trial officer to be your witness? Are you going to tender the trial proceedings? So for us to trigger investigations or then from there proceed to prosecutions, there must be a complainant. So unless you want to make use of the private proceedings, private prosecutions, or really it clearly comes out in the course of the trial that this is a lie and probably it's on record. But there you're going to have the challenge, because now you have to call a state attorney probably as a witness, you have to call the defense, the trial officer. So I think those are some of the complexities. Maybe in my next topic, if VLS invites me, I should ask for such a topic.
I hope they do. I really hope they do. Some lies are black and white, are not even gray. And they are told in the courtrooms, and they just go on. I believe it's an offense that is oftentimes neglected.
But maybe that should be a food for thought.
Yes.
I think really, personally, I haven't addressed my mind so much into that. And also we are talking about case backlog and all that. So if you're going to start picking up all these nitty-gritties, then we'll just be clogging the system any further. But I mean, if it's really a serious one, then we can take that up. Maybe next time you have such, you can just come to our office.
I think members' affairs are online and they are noting, because I believe perjury goes to the root of the proceedings, and it's really important. Then secondly, this is from me.
Yes.
There is an abnormally rising trend of prosecution of advocates. And I am wondering, are the advocates becoming more criminal, or are they falling prey of prosecutorial ego? In your view?
I don't speak for the office of the DPP. I'm not the PRO, please. My personal view, like I already said, that as prosecutors, the decision to charge is guided by several factors. I already went through them.
Yes.
So really, as advocates, we're expected to conduct ourselves professionally at all times, and there shouldn't be any excuse. I expect you to sit here and condemn any advocate who unprofessionally conducts business. That we should not accept it at any one time, whether it's our close ally, a friend, associate. We shouldn't allow that. We should always be professional in whatever we do. That applies to prosecutors as well. If you also know that there are prosecutors or a prosecutor who is unprofessional, please let's not condone that. But where there is evidence on file that an advocate has committed a crime, why won't we prosecute? The options are there. The advocate can opt for plea bargain or prove their innocence. But what we shouldn't allow is just prosecuting for the sake of it where there is no evidence. But if clearly there is evidence, then it's good to send a message out there if they fail to live up to the professional expectations.
Yes. The last one from someone here is you have made mention of balancing public interest and the rights of the accused in prosecutorial discretion.
Yes.
And my question is, how do you maintain objectivity under intense public pressure in some of these cases?
Well, I must say it's not easy, but it is about sticking to the professional standards for us as prosecutors. And for us, there are those guiding principles, the evidence and all that. There are cases where on social media you read totally different things. Some have prosecuted. What you read on paper or social media is totally different. I only wish there were opportunities whereby we could be allowed to invite, the public to peruse these files. Because the evidence on file can be totally different, but what's on media, and some people have learned that art of having trials on media, which is wrong. And our offices are open. If you feel that maybe someone is being unfairly treated or something is wrong, please use the complaints mechanism. It will be addressed. It may not be to your satisfaction, but your complaints will be addressed. And two, let's not believe what is out there. Let's believe what is in the police file and ultimately what the witnesses say in court. Because for us, we are guided by what is on the file, not in media. So media has its own version. Of course, it's about publicity. Their interests are different. And for us, our mandate is different. So sometimes it's just a total misconception, I would say.
I am a practicing advocate.
Yes.
And maybe after here, I'll be sharing with you that the view on the ground is actually different. The common saying these days is "kuground virala."
About what in particular?
about police investigations and how files are sanctioned. It's a difficult process. It's a painful process out there. Allow me ask the last question. Actually, I think he seeks your comment. Wary Gerald, he says, state sanctioned a file on trespass, yet the accused won the civil matter against the complainant. And we are in court, yet state knows the accused won the civil matter. Before you comment on that, I don't happen to share the language Chomkama Brian is actually using, though I must admit it should be through pain.
We're used to those by the
state attorneys of nowadays that in offices. I don't want to use that word, but kindly respond to Barry Gerald. But advocates, I should really be honest with you, they are sometimes sort of frustrated by some of the things that actually happen inside those offices. I know you could be a different one. And by the way, there are very good state attorneys out there. But then we also have bad ones. Like we have bad lawyers and we have the good and the bad. Please respond to Barry Gerald.
You know, I'm a bit keen on social media. And once in a while, if I see it's really too much against us, the state attorneys, I intervene sometimes.
Yes.
The thing is, complaining to yourself doesn't help. If you've had an encounter with a state attorney, prosecutor, why don't you report it? Why don't you document it if you know that you're sure about what transpired? We have a disciplinary committee, sanctions and rewards committee. We have a complaints mechanism. We've had state attorneys prosecuted in court. I'm sure you've heard of that, where they've committed crimes. So we are not immune, by the way. So if you have a genuine concern about a particular state attorney, please follow the complaints mechanism and action is taken. We even have a department of quality assurance that investigates. She's ever in the field moving around to follow up on these investigations. But the problem is, you people, most of you prefer media, social media targeting, and you don't even divulge the details. Look at this one calling us thugs. I am not a thug. I know many prosecutors are not thugs, so where you get that from or what your perception is, I'm sorry for you, but we are not thugs. We are professional. If you have any proof or evidence, please bring it forward. Don't just be there on social media calling us all names and lumping all of us. Some of us really have names to protect.
I must admit, I think it's getting very hot in the chat room. It's getting very, very hot. Brian, kindly come down. Maureen, please come down. Your comments have been read. We
Actually,
have run.
Brian, kindly lodge a complaint. Maybe you've not lodged the complaint. It will be handled. Just put it in writing. If it's at the RSS station, lodge your complaint to the regional officer. If you're not satisfied, please lodge it at DPP headquarters. It will be handled, please.
Yes, thank you, Maureen. Maureen says she practices in Imbara and she must state some state attorneys are good.
Thank you very much. Thank you.
All right, some small addition to Brian. I think this should be a follow-up, but it comes from Semfuka Robert. He says, what went wrong with the DPP complaints desk? A file has been called 4 times, but it has never reached the right office. It is always intercepted by the big powers. How best should we complain?
I don't have the complaints detailed here. I'll do, but Brian, you can get in touch with me. You can share the number.
Okay.
I can see how to help. Is it Brian or whoever raised it? Yes.
Semfuka Robert.
Because our complaints desk really works. It works, yes.
Yes, Semfuka, you're now going to be helped. I hope it is 3 minutes past midday. We are already into his worship's time. Ladies and gentlemen, join me to thank Miss Immaculate for the wonderful presentation, for the candid discussion. Really, we have very many questions as advocates that would like to put our colleagues in the ODPP's office. The time today would not really be enough for you to canvass all this, but you've really done wonderfully well. Thank you very much. I hope ULS will organize for us something that is more engaging so that we can have to share the pains in private practice and vis-a-vis the persons that are entrusted with the powers to help us direct investigations and ensure that our clients receive a fair trial. Thank you very much.
Thank you. Just because before I leave this, if you have concerns and all that, I can help. Feel free to reach. Like I was introduced, I'm also the president of Uganda Association of Prosecutors. So I have a platform where some of these things can be addressed. So feel free to reach out, really. Don't die in silence. If we can help, we really promise to help. Thank you.
You're welcome, please. Have a great afternoon.
You too.
Yes, our dear members, distinguished guests online and everyone there, we have now seen what happens when the defense sharpens its sword and when the prosecution polishes its shield. This time we go to the referee, one who trains the next generation of advocates. Ladies and gentlemen, allow me to introduce His Worship Timothy Lumunye. He is a judicial officer whose reputation precedes him, I must state. I have received his bio. Among today's panelists, it's on a number of pages. It's on a number of pages, but I'll briefly go through it. He's a candidate of LLM in the University of East London. Between October 2011 and August 2012, he obtained a postgraduate diploma in legal practice at the Law Development Center. Between September 2007 and July 2011, he obtained his Bachelor of Laws degree, second class upper division at UCU Mukono. In 2006, that is when he got his UACE. I think let's get to his professional experience. He's presently the Chief Magistrate sitting at the Law Development Center. Between June 2022 and December 2024, he was a personal assistant to the Chief Registrar of the Judiciary of Uganda, and he executed very many roles while he was there. Then, between 2020 and 2022, he was a magistrate grade 1 at Natete Rubaga Court. Between 2017 and 2019, he was the private legal secretary to the chambers of the principal judge on special assignment. Between 2014 and 2016, he was the magistrate grade 1 for courts of judicature. Then 2014, 2021, he was a teaching assistant at the Faculty of Law at UCU. He happens to hold several other responsibilities. He's a member of the task force on the proposed High Court circuits. He therefore has a contribution to the good work that is going on. He's a secretary to the Courts Bailiff Licensing and Disciplinary Committee. He's a former member. He's a former member of the UCU Faculty of Law Curriculum Review Committee. He's a member of the Judiciary Juvenile Justice Committee. He's a member of the Judiciary Case Management Committee. We hope to see much change quite soon. He has some publications. He has an article on COVID-19 and the administration of justice in Uganda. He has an article on mobile courts in developing a child-responsive judicial system, why and how, and he has a bailiff's manual on execution. Ladies and gentlemen, he brings the unique perspective of the bench and the classroom. Let us warmly welcome His Worship Timothy Lumunye. Your Worship, you're welcome to today's discussion. Please guide us. Are you court or you're an officer of court?
I'm an officer of court.
Much obliged. Let's proceed, Your Worship.
Thank you so much. Thank you so much, moderator. Thank you so much, members, for tuning in. And thank you so much, Uganda Law Society, for the invitation. I'm here to share on a topic, the role of Defense Counsel in execution of plea bargain agreements. The role of Defense Counsel in execution of plea bargain agreements. In a word of introduction, plea bargaining was formally introduced into Uganda's criminal justice system in May 2016 through the Judicature Plea Bargaining Rules SI number 43 of 2016. Under the said rules, a plea bargain is defined as the process between an accused person and the prosecution in which an accused person agrees to plead guilty in exchange for an agreement by the prosecutor to drop one or more charges, reduce a charge to a less serious offense, or recommend a particular sentence subject to the approval by the court. The scope of this agreement is provided for under Rule 16 of the rules, and here a plea bargain may be in respect of the following. 1, a promise to plead guilty in exchange for a recommendation for a lesser sentence. So if you have instructions to defend a client and the client confides in you that they indeed committed the offense, and you have perused the files and you want to recommend a plea bargain, one of the things you can look out for is a promise to plead guilty in exchange for a lesser sentence. B, a promise to cooperate as a witness for the prosecution in exchange for reduced charges or a reduced sentence, or both. C, to plead guilty to a minor and a cognate offense, or a lesser offense, or some charges or counts in exchange for a withdrawal of one or more charges or counts in the case of multiple charges. So when we talk about a plea bargain, it carries the above forms. Could be pleading guilty for a recommendation of a lesser sentence. It could be a promise to cooperate as a witness. It could be your client pleading guilty to a minor and cognate offense. It could be your client pleading guilty to a lesser offense, or it could be pleading guilty for some charges to be withdrawn. Now, where the bargain is successful, the process culminates into a plea bargain agreement. So what does that mean? It starts with a bargain, and if the bargain is successful, that's when we talk about a plea bargain agreement. So there are two things there. There's a plea bargain. We have given the scope under Rule 6 of the rules, and when the bargain is successful, that's when we talk about a plea bargain agreement. The Court of Appeal has recognized the plea bargaining as an essential component of the administration of justice that, if properly administered, should be encouraged because it avoids the resource-intensive burden for full trials. Currently, all trials in the High Court are by way of, majority of the trials are by way of session system. So if plea bargain, or if plea bargaining is handled properly and administered properly, it can reduce on the burden, on the resource intensive burden of full trials, because for you to be able to complete a full case in terms of value attached to a full case, you are looking at the range of 800,000 to 1 million to complete one case. Whereas if it is a plea bargained agreement, the statistics I have here, the cost that is attached to a plea bargain case, for the High Court, we are looking at 400,000. So that means that you're coming all the way from 1 million to 400. And for the lower bench, each plea bargained case currently is costed at a cost of 200,000. So if managed properly, it could reduce the burden, since most of the trials are by way of session, and sessions are expensive. So the paper that I'm going to discuss with you examines the specific duties and responsibilities of defense counsel throughout initiation, negotiation, execution, and conclusion of plea bargaining agreements under the Judicature Plea Bargaining Rules of 2016. Objectives and constitutional foundations of plea bargaining. The objectives of the plea bargaining are set out in Rule 3 of the plea bargaining rules and include enhancing the efficiency of the criminal justice system, reducing case backlog and prison congestion, encouraging accused persons to accept responsibility, facilitating amicable agreements on sentence, involving the victims in the process, and providing swift relief from the uncertainty of trial. Because what happens when a person is, for example, produced in the magistrate's court and they are charged with a capital offense, our role as magistrates is to simply communicate the charges, because we don't have powers to do anything in that case. And we wait until DPP is done with the investigations. We commit the accused persons for trial. But in our ruling, normally we say you are committed to for trial in the High Court during the next convenient session. So convenient at who? Convenient at the convenient with the court. So there is uncertainty there. But for plea bargained cases, if your client is willing to plead guilty, such cases do not have to wait for for sessions. Plea bargaining aligns with several constitutional principles governing the administration of justice under Article 126 of the 1995 Constitution, including expeditious justice, victim compensation, reconciliation between parties, and substantive justice for all irrespective of the means. It represents a shift from purely retributive meaning the focus now, if you don't engage other alternative dispute resolutions, the focus in criminal justice is to punish. Plea bargaining introduces a shift from retributive to restorative justice that involves a process that involves offenders, victims, and the community. Now, let's look at the role of defense counsel. What is your role as defense counsel? Upon being instructed, whether privately or on state brief, defense counsel must exercise due diligence. You must exercise due diligence. And this includes, 1, meeting the accused promptly to provide legal advice and counseling. Colleagues, don't meet clients in corridors of high court. When you receive this brief as a lawyer on state brief, make an effort. Make an effort and go to prison. Make an effort and get in touch with the relatives. Make an effort and create time for this accused person that you are going to represent. Give the client time. 2, confirming that the accused understands the charges. That is your duty, to confirm that the accused actually understands the nature of the charges against them. 3, establishing the period spent on remand. That is very key, because when it comes to sentencing, this period is deducted mathematically. So there is that first document that we give to accused persons when they appear before court. The very first time, that remand warrant is the one that you should use, because it has a date when the person was first remanded. 4, apply for full disclosure under Rule 7 of the plea bargaining rules. Then also assessing the strength of the prosecution case. It is your role. The person is charged with murder. The person is charged with aggravated defilement. The person is charged with rape. Assess, especially after full disclosure. Advising on the available pleas and their consequences. We have several pleas and the consequences are different. Where evidence is overwhelming, recommending consideration of plea bargaining as a strategic option. There are cases that are straightforward, where you don't really need to put up a defense, but rather recommend, and your role will now be limited in mitigation as a way of reducing the sentence. Now, let's look at initiation of a plea bargaining. Plea bargaining. How is this agreement introduced in court, or how does the process start? Plea bargaining may be initiated orally or in writing by either party at any stage before sentence is passed. That is under Rule 5. It may be initiated orally or in writing by either party at any stage before a sentence is passed. What does that mean? That even after conviction, you can plea bargain. Defense counsel frequently initiates the process on behalf of the client, particularly when the accused person is unaware of the option. The courts have emphasized that judicial officers must not block late initiations and are obliged to suspend proceedings to allow negotiations. When you inform us in court that your client is considering plea bargaining, as a magistrate, as a judicial officer presiding over that case, I'm supposed to suspend proceedings to allow you to negotiate with the opposite party. This is what happened in the case of Niseko Adams versus Uganda. It's a High Court Criminal Appeal number 263 of 2017. The judge dealt with the ground of appeal arising from the trial magistrate's failure to follow procedure when the accused stated that he wanted to enter a plea bargain. The magistrate had instead proceeded to handle the matter as an ordinary plea of guilty, thereby misleading the accused into thinking he was in a plea bargain. From the record of proceedings, the case was at defense hearing when the accused stated, "I am for plea bargain," like the way they normally say, "I am for plea bargaining." The state replied, "The case came for trial. The accused was put on the list for plea bargain, but it failed." The accused said, "I am willing to compensate the complainants. I admit I committed the offense. I will pay 2 million shillings on 20th March 2017. The state said, "Let him pay the 2 million shillings from prison." The trial magistrate then read the charges afresh, and the accused pleaded guilty, despite the accused having previously informed the court that his lawyer was coming and would sign the plea bargaining agreement. It was held on appeal that the court is obliged to give the initiating party a chance to discuss the case with the opposing party. The court is obliged to give the initiating party a chance to discuss the case with the opposing party. Even though the temptations to reject a plea bargain at a later stage in the proceedings is high, a judicial officer must not be seen to flout the rules of procedure. It was also held, still in the same case, ideally, plea bargaining should take place at a time of plea taking to enable the state, the accused, and defense counsel to agree on amending the charges where necessary. In that case, the magistrate blocked the plea bargain at the defense stage. Now, that is contrary to the rules, because the rules provide that the plea bargaining can take place anytime before sentencing. Now, I note that where a request is made during the hearing, the court should suspend the proceedings and grant the parties sufficient time. And also, counsel, do not rush the process, especially the lawyers who are on state brief. You're representing people who are charged with very serious offenses. You're representing people with very grave offenses that carry very heavy sentences or very long-term sentences. So don't rush the process. It's not about statistics. It's not about statistics. Statistics are desirable. I know there's a temptation. You are in a session, you go meet the accused person. Ideally, you would want so many to be finished through plea bargaining so that you can quickly work and go back to Kampala. Now, that's not correct. Do not rush the process. Statistics may be desirable, but justice must not only be done, but must be seen to be done. Now, as a defense lawyer or counsel, you have a duty to ensure that there is full disclosure. Defense counsel must insist on completion of prosecution. Defense counsel must insist that the prosecution discloses to enable informed decision making by the accused. The duty of disclosure is constitutionally entrenched and has been widened by judicial interpretation to include material in possession of complainants, not merely that which the prosecution intends to rely upon. Ensure disclosure of all relevant information to the accused. Copies of documentary exhibits are to be provided to the accused to enable him or her to make an informed decision. There's that case of Su Yon Kung and another, Constitution Reference number 6 of 2007. The court outlawed trial by ambush in criminal matters. Disclosure of prosecution evidence must be made except in circumstances of, for example, issues of national security or of safety of witnesses. Surely, you cannot plea bargain. You cannot have a meeting with that client if you don't know the case against your client. So make an effort. Ensure that all the relevant information that you will need, that will help you in mitigation, that will help your client make an informed decision, must be collected and must be availed to you. The other is participation in negotiations and judicial consultation. As a defense counsel, you have a role to participate in negotiations and judicial consultation. Defense counsel negotiates the terms of the agreement, that's a charge reduction, sentence recommendation, compensation, etc., and must consult the judicial officer on possible sentences before finalization. Look at Rule 8, Sub-Rule 2. Such consultations form part of the record. So here what basically happens is that after the prosecution and the defense have agreed on a proposed sentence, before you go to court for confirmation of that sentence, you are supposed to meet with the judicial officer in chambers and then consult the judicial officer on the proposed sentence. The rationale there is to ensure that the sentence that the parties have agreed upon does not amount to a miscarriage of justice. The judicial officer at that stage is not is not imposing their own sentence. Theirs is to guide or give a range to guide. These are the facts, these are the aggravating factors, these are the mitigating factors, this is the proposed sentence. Then the judicial officer will look at all that and then either agree before you go for confirmation, or reject and give reasons, or send you back and give you a range, but not to impose their own sentence. The other role as a defense counsel, you have to safeguard to ensure that the agreement has been done or has been reached voluntarily. So before the accused signs the plea bargaining agreement, defense counsel must, 1, explain the entire agreement and its consequences in the language the accused understands. In the language the accused understands. The entire agreement and the consequences in the language the accused understands. Ensure an interpreter provides a certificate of accurate interpretation where the agreement has been initiated by the prosecution. Explain the constitutional rights being waived, like a right to full trial, the presumption of innocence, a right to remain silent as required by Rule 12 of the rules. Failure to ensure that the accused fully comprehends the agreement renders it defective and liable to be set aside on appeal. Let's look at the case of Rele Bosco versus Uganda. It's a High Court Criminal Appeal number 531 of 2016. It's a court of appeal, criminal case number 531 of 2016. The justices of the Court of Appeal, this is what they held in that case. The record shows that the trial judge read the charge and the facts to the appellant, but it does not show that the court was informed of the ongoing negotiations or consulted with regard to possible sentence prior to the court's approval. The accused and his lawyer must labor to inform the court about the ongoing plea bargaining negotiations and consult the court on its recommendations on possible sentence, especially before the agreement is brought to court for approval and recording. This would be this would be the appropriate stage in the proceedings for the court to recommend to the parties to consider mitigating factors and the period an accused person has spent on remand. The court must ascertain from the accused whether he or she voluntarily signed the agreement after it had been explained and translated in the language he or she understands. If the accused so confirms, he or she is invited to execute a confirmation. Now, in this case, the guidance that the justices of the Court of Appeal have given is that when parties, when defense counsel, when the state attorney, you appear in chambers to make consultation with the judge or with the judicial officer about the possible sentence that you want to agree on, the judicial officer should make a record of the consultations. And during that, and at that stage, the accused and his lawyer must labor to inform court about the ongoing plea bargaining negotiations and consult the court on the recommendations and possible sentence, especially before the court approves or records it. So you come, appear before the court, you inform court on the possible sentence, and then court will either agree, and if court does not agree, they have an option of rejecting it and recording the reasons why the agreement has been rejected, or proposing a range, but not imposing their own sentence. Now, after parties have agreed on the sentence and the consultations have been made with the trial judicial officer, that's when now you move to open court for recording and confirmation of the sentence. And that takes us now to the next level, which is court procedure and confirmation. Now, during court hearing, governed by Schedule 2 of the rules, the defense counsel must, 1, confirm the terms of the agreement. Now you are in open court. Must confirm to the judicial officer the terms of the agreement. 2, verify on record that the plea is voluntary and unequivocal. Must verify on record that the plea is voluntary and unequivocal. 3, present mitigating factors. 4, ensure the victim or the complainant is heard where appropriate. And also, object immediately if court diverts from the agreed sentence. As a defense counsel, you have to object immediately if court diverts from the agreed sentence. In the case of Agaba Emmanuel and 2 others versus Uganda, the appellants were convicted of murder and sentenced to 20 years and a plea bargain, despite the agreement reflecting 18 years. They appealed against the sentence. They appealed against the sentence, and the sentence was set aside. The court observed, in our view, plea bargaining creates an agreement between the prosecutor and the accused, with all the features of the agreement in the law of contract. The court plays the role of a regulator of the agreement to ensure that it conforms to the needs of justice of the case. But the court is not privy to the agreement and cannot redefine it. What the court may do is to reject the plea bargaining agreement where it is satisfied that the agreement may occasion a miscarriage of justice. But this should not even be done in open court. This should be done during consultations. In other words, by the time you decide that now we are going to court for recording and confirmation of this agreement, the judicial officer should be satisfied that the proposed sentence will not amount to a miscarriage of justice. Should the court reject the agreement, it shall record reasons for the rejection and inform the parties. the agreement becomes void and shall be inadmissible in subsequent trial proceedings or any trial relating to the same facts. And also the court should refer the matter for trial. Now, the other duty is, as a defense counsel comes in on enforcement of the agreement and appeals. Defense counsel retains the duty to ensure strict compliance with the agreed terms. Defense counsel retains the duty to ensure strict compliance with the agreed terms. Any judicial diversion, whether more severe or more lenient, constitutes a rejection of the agreement, rendering it void and requiring retrial. Counsel must also ensure that the period spent on remand is mathematically deducted from the sentence. In other words, for example, if parties agree to a sentence of 20 years, when you are plea bargaining, you don't include the period spent on remand. That is done mathematically at the time of confirmation of the sentence. You agree on your sentence based on aggravating and mitigating factors. You come up with a sentence, let's say if it is 20 years, and now when I move to court at the time of sentencing, confirming the sentence, I have a duty to mathematically deduct the time that the convict has spent on remand. So if you agreed on 20 years and the convict has been on remand for 3 years, that means that the period they are going to serve will be 17 years. Now, withdrawal from the agreement. Before a sentence is passed, defense counsel may, on the accused's instructions, withdraw from the plea bargain. Remember, we said parties can plea bargain at any time before sentencing. That means even after conviction, you can still enter into a plea bargain. But as defense counsel, if the court has not yet confirmed that sentence and your client informs you that they are no longer interested in the plea bargaining, they're no longer interested in the plea bargain, you have a duty and you can withdraw. You can inform court to withdraw from the plea bargain. Once sentence is pronounced, however, the agreement becomes binding and the accused person cannot subsequently reject it or disown it unless there are grounds like misunderstanding, coercion, or misrepresentation. In conclusion, the effective execution of a plea bargaining agreements in Uganda depends heavily on diligence, ethics, and competence of defense counsel representation. Counsel serves not only as the accused's advocate, but also a guardian of procedural fairness, ensuring that the agreement has been reached voluntarily, ensuring full disclosure, ensuring strict adherence to the agreed terms. By discharging these duties, defense counsel contributes significantly to restorative justice and efficient objectives that the rules provide and seek to achieve in the Uganda's judicial system. I want to note here that for the first time ever since the introduction of plea bargaining in the Uganda judicial system, we now have more convicts than remandees. We have more convicts than remandees, and courtesy of innovations like plea bargaining. Thank you so much. The questions are welcome.
Thank you very much, Your Worship. Very many questions have actually come through. We have enough time to canvass them. There's a brief one here from Rafael Baku. He asks, can a plea bargain agreement in a capital case be entered by a magistrate court?
No.
Thank you. I hope, Council, that has been answered. Now, Maureen Wamanya says, I have a scenario. As you state, plea is a negotiation. However, in most bargains I have attended, state comes with a threshold of a sentence, as in already predetermined. For example, for murder, they are not allowing anything below 22 years. Does this beat the whole essence of plea bargain? When an accused rejects the offer, it's recorded on their file. It's recorded on their file. Excuse me. Yes. And used against them. So, speaking of sentence, what His Worship is saying is different from what is actually on the ground. He says, "Ku ground Moko," as the saying goes, state calculates a sentence having the remand period in mind. Forgive, he or she will refuse an offer for reasons like if the remand period is removed, the sentence is small. Then you wonder, it's time. Isn't time on remand served?
Yeah. When you are negotiating, the parties are not supposed to negotiate on the time spent on remand. You look at the aggravating factors, you look at the mitigating factors, you agree on the sentence, you appear before a judicial officer for consultation of the proposed sentence. If the judicial officer is satisfied that the sentence does not amount to a miscarriage of justice, then the judicial officer will move to court for recording and confirmation of that sentence. If the sentence agreed upon is, for example, is 20 years, and the accused person has been on remand for 3 years, when confirming the sentence, the judicial officer has now to mathematically deduct the 20 deduct 3 years from the 20 years. And that means that the accused person or the convict will serve 17 years. Of course, I understand that the area that we are discussing needs, the training has been done, but you might find that the practice, the practice is also what? Different. Yet the rules are very small. You don't even need to read them for 1 hour. The rules are very, I think they are one of the simplest, more clear rules that we have. Stick to the rules. Otherwise, the agreements that you are entering into will be set aside on appeal. Stick to the procedure. The procedure is provided for in Schedule 2 to the rules.
Thank you very much, Your Worship. Councillor Fuka Robert asks this question. Isn't the court already biased during the trial process after rejecting the plea bargain agreement?
Yes. Ideally, if I reject a plea bargaining agreement, I should not sit in that case. Because during consultation, the courts have guided, I must record the what? The reasons. These are decisions. They are there. You read these decisions. They are there. I must record the decisions. The best practice, to be fair to this accused person, would be for another judicial officer to handle the file. To handle that file. So because, I mean, we are saying that for a plea bargaining, for you, the starting point for a person to be interested in plea bargaining is that they must admit that they committed the offense. So to avoid those biases, it would be better, for example, at ALDC court, we are 3. If I handle one plea bargain and it fails, or I think that it will lead to a miscarriage of justice, I can give it to another colleague who has not handled the agreement, and then they hear the case.
Thank you. Much appreciated. Now, Your Worship, you have made mention, this comes from me, you've made mention of voluntariness. And you state, and I agree, that it is a key element of a plea bargain agreement. Voluntariness lies at the intersection with the accused that have served long remand periods, sometimes longer than the maximum sentence.
Yeah.
I don't know. In your view, would this be voluntary, or it would be an arithmetic issue of justice?
The plea bargain is, first of all, plea bargain is for only, this is the training we give when you go to prison and the sensitization that we give. For an accused person to participate in plea bargaining, they must know in their hearts of hearts that they committed the offense. Plea bargaining is not for the accused persons who have overstayed on remand. Yes, it is not for the accused person who have overstayed on remand. It is not for those, it is not a shortcut for you to leave prison or for your client to leave prison. Because when you do that, you'll actually be telling a lie to court. It is for only those who know that in their hearts of hearts committed the offense. What happens to those who know that they didn't commit the offense and have overstayed on remand? If they are not heard, let them be patient. The trial, the hearing will come.
Your Worship, I very much appreciate your answer. It's technically correct.
Yes.
As a member of ULS, step in our shoes. I have a client who has been on remand. He has been accused of a misdemeanor. He has been on remand for, let's say, the last 5 years. And a plea bargain session is in prisons. Step in my shoes and advise this client to pass it and wait for 2 more years to prove his innocence in court. Don't you think this is a bait?
I would wonder how a person can be in prison for more than that for a misdemeanor. Currently, we shouldn't have such, because we have so many magistrates. We have so many magistrate grade ones. Courts are spread. A misdemeanor and you are still on remand for more than 2 years, then there is a problem with the judicial officer. Or there is a problem with the lawyers representing that person. There's a problem with the lawyers representing that person. I am aware that there are people who are on remand are charged with capital cases, and they have spent 2 years, they have spent 3 years, they have spent 4 years, and they have not yet been heard. Those, I agree, they are still there because trial is by session system. But for cases that are in the lower courts, I think that should be a thing in the past. If you come to my court and you find that a person is on remand and he has been in prison even for more than 1 year, there should be a problem. Bail, yes, there are those who are on bail and they are still reporting because of different things. Witnesses, IOs transferred, this and this, but not on remand. Not on remand at least.
Thank you very much. Castle Semfuka Robert thanks you for the wonderful presentation and says greetings to the most disciplined judicial officer of our time. I am not making a comment on that. Maureen says 8 years. I think
for capital. I should be referring for capital offenders, yes.
Okay, so Your Worship, there's a question that came in earlier, and I wanted to pick your opinion on that. A magistrate at the Standards and Duties Court, Mashindye, oftentimes, and I have had these complaints from colleagues, advises the accused persons not to use lawyers. How can you use lawyers in such a simple matter? I personally had testimony of this, not in my own case, but a friend has told me this is what happened to me. And the friend tells me that when he insisted and remained in the case, there were 4 accused persons. The 3 that had no lawyer were all acquitted. The one who remained with a lawyer to the end was convicted and sentenced to, I think, a few years in prison. I would want to pick your comment on something like that to be happening in a judiciary whereby we are supposed to be colleagues from the bar one end and to the bench on the other side.
One, I cannot independently confirm because I'm just hearing it from you, but I'll explain the law that every accused person has a right to legal representation. And if it's a semi-capital offense or if it's a capital offense and the accused person cannot represent themselves, then they are entitled to state brief representations. And like you have said, we are all officers of we are all officers of court. Ideally, we should be working as colleagues. So that is all. That is all I can say. Although I have experienced also a scenario, by the way, where an accused person was charged with a traffic offense. You know traffic offenses. These are strict liability offenses. And later we learned that actually, because he pleaded guilty after that, he had actually committed the what? The offense. As a lawyer, let me also ask you, would you advise that person to apply for bail for a strict liability offense, traffic? As a first option.
For strict liability offense.
Yeah. Like traffic. You don't have a driving license, or you don't have a third-party license.
Your worship, in my view, I would advise him. Actually, he needs a lawyer more than the one who actually committed the offense. And this is my view. You realize that someone can be accused of driving without a valid driving license, while he has it, but not right there.
No, and the facts are that he actually committed offense. He didn't have the driving license. He didn't have third parties, insurance. Would bail be your first option to such a person?
Bail being my first option? You've defined your facts, and I want to leave this to the professional judgment of the individual. All right. So, I want to pick your opinion on the growing trend of judicial officers asking. Sorry, I want to pick your opinion on the growing trend of judicial officers asking questions in cross clarity, but in fact they are not clarifying on anything. They are purely making a case for probably the defense or a case for the prosecution. What's your view on that?
Yeah, the courts have a right to ask questions for clarity, but when these questions are asked, in my record, I should actually record the question that has been asked by the court and then the response. You see, when you come to court for justice. You come to court for the truth. If it's ideally, when you're asking that question, it should not be building a case for the prosecution, it's not be building a case for the defense, but it should be a question that you think will help you understand this case clearly. Because if you don't ask those questions during the hearing, when it comes to writing a judgment, it may not be so easy because you can no longer call the parties. The questions, that's why you have to be very sober and very alert. You have to know, you have to understand the case, because everything that you need to ask as a judicial officer that will help you in judgment writing, you need to ask it during the hearing. So we ask questions for clarity. We don't ask questions to build cases for either party.
Thank you very much. Getting back to plea again. Your Worship, what are the biggest errors defense counsel commit during plea negotiations?
One, and the gravest, is failure to explain to the accused person their rights under the what? Under the agreement, which are clearly provided for in the rules. When the accused person signs up for this agreement, defense counsel has a duty to explain to them their rights under this agreement, because that will be the basis of this person challenging the agreement on appeal. You must ensure that the accused person has understood that by signing up to this agreement, they have waived their right to a full trial. You must ensure that by signing up, as defense counsel, you must explain the entire agreement and the consequences in the language that they understand, and also ensure that by them signing up to this agreement, they have waived their rights to a full trial. Because if that does not come up, that's why in signing, the parties should sign this agreement in the presence of the judicial officer. You don't come with a signed agreement. When you agree as parties, and then you come to court for consultation, that is in chambers, and then court confirms the proposed sentence, and then now we move to court for recording and confirmation. I, as a judicial officer, I have to also take you through all the rights to satisfy myself that they have explained to you those rights, that you have understood them, that you have agreed to waive your right to full trial. And then when I satisfy myself with that, then that's when I invite the parties to sign the agreement. The agreement is not signed in prison. The agreement is not signed in your chambers. The agreement should be signed in open court at the time of recording the agreement and confirmation. Please look at Schedule 2. Look at Schedule 2. Schedule 2 of these rules. If you allow me briefly, I can take you through this Schedule 2 on what is supposed to happen. When you appear before court, the parties are called, the representatives are introduced, the state introduces the plea bargaining agreement, the defense confirms the agreement, court informs the accused of his or her rights in a criminal trial and the effect of the plea of guilty. Court finds out from the accused whether he has voluntarily signed the agreement, and if it has been explained to him and translated to him in the language that he understands. If the accused person confirms, then is invited to execute in open court, to execute a confirmation. If the agreement is accepted by the court, the same is received on court record, and then the charge is read and explained to the accused person in the language that he understands. Please look at Schedule 2 to the rules. Ensure that because a plea bargaining agreement has a very strict procedure, that it's very easy to challenge this sentence on appeal. If either the prosecution does not follow the procedure, if either defense counsel does not follow procedure, or if me as a judicial officer, I also don't follow procedure.
Thank you very much, Your Worship. Let me pick Omonya Rama.
Yes.
He makes a comment. One of the challenges, especially with magistrate courts, is that most magistrates treat defense lawyers like adversaries. There is very little or no courtesy extended to a defense lawyer. He adds that most times magistrates want to play to the gallery a lot. A simple matter where the magistrate can ask the counsel to approach the bench and exchange views in hushed tones, or call the counsel to the chambers to resolve an ugly impasse would be a good thing. Most magistrates are very combative and want to show who is the boss. But I want to leave that at that. You can comment, but
Yeah, I think that's a training. That's a training need. We are officers of court. We are civil servants. We are servants. We exercise that authority on behalf of the people. We don't. I don't have a court because there's no court that is in my name. I exercise that power. I exercise judicial power on behalf of the people. And then there's what we call DCC, District Chain Linked Committee, where all the justice stakeholders meet and then you agree. So what I would advise my brother Rama, if you are facing such challenges, those are issues now to be discussed in your DCC. Come and talk to me. Sometimes I'm not aware, by the way. I may not be aware, but come and talk to me. In that forum, talk to me, because in that forum now you iron out local challenges, because the challenges at LDC may not be the challenges in Nakawa. The challenges in Nakawa may not be the challenges in Mengo. So in your DCC, that's the platform now we should use to iron out. Say, look, I think if we did this better, I think if you were more approachable, I think if you would prevail over your staff, maybe you would be able to see what is happening. You know, because I might think that all is well, yet a lot is going on. So in that platform, that's when you can address such issues.
thank you. Your Worship, allow me pick your opinion. You realize upon conviction, an accused person might want, actually the convict, might want to enter a plea agreement. How should defense counsel, who has just lost a matter, approach the plea discussions with a client who is frustrated after paying hefty instruction fees and everything? He has lost a matter, and you're the same person appearing before him telling, accept this number of years.
The plea bargaining, it is not, it should not be the lawyer telling a convict in that case to go for plea bargaining. Plea bargaining is for the accused. I don't know if you get where I'm coming from. It's not that because you have lost, now you want a soft landing, so advise, no. Unless you are advising the convict at that stage professionally. You've looked at my judgment, you agree with my judgment, and now before we go for sentencing, why don't we plea bargain on the sentence? That's very okay. But it should be the accused person should voluntarily, that aspect, it is very key. The accused person should accept to the proposal. It should come from the accused person. Even when you offer guidance, a professional opinion, it is up to them to either take it or to leave it. Because remember, it's not your case. You are there to represent and to do your work professionally, but this is a decision, because the sentence that is going to be served, it's not you who is going to serve it. It's this accused person. So how should they approach? If at that stage I've given you a judgment and you agree with my reasoning and you agree with my decision, just inform the court, like with the things I've been discussing. Inform the court that you have talked to your client. Your client is interested in plea bargaining. What is the court supposed to do? Suspend the sentencing and then allow parties to go and negotiate on the sentence. That's how it should be approached.
Your Worship, I am not going to bother you with the inadequacies of your callings, because honestly, I will be asking you questions that you cannot probably answer. Your Worship, I want to appreciate your time. Thank you for clarifying the pivotal role defense counsel must play in ensuring that plea bargains remain voluntary, ethical, and just. We truly appreciate your guidance
Thank
and
you
for
so much.
having reserved some time for us. Ladies and gentlemen, today we have heard from the defense, from the prosecution, and the bench. We have talked through the best practices in criminal defense, the delicate balance of prosecutorial discretion, the judicial expectations in plea bargains, and the art of appellate advocacy. If there is one thing this session reminds us, it is that criminal practice is not supposed to be a battle between enemies. It's supposed to be a partnership in pursuit of justice. Ladies and gentlemen, on behalf of the organizing committee, I thank all our distinguished speakers for their wisdom and all of you for your attention and engagement. Ladies and gentlemen, this yearly session is formally closed. Enjoy the rest of your evening, and most importantly, practice well, practice ethically, and practice with purpose. Greetings to my president, wherever you are, and have a great afternoon.